My lord, this matter was last listed on 6th of...
Judgment is on.
Okay, sorry.
They have modified the visitation rights granted and dissolved the marriage under Article 142. The mother would be entitled to visit the daughter twice every month after fixing a convenient date between the two parents. Yes.
My lord, this matter was last listed on 6th of the November.
6th of?
6th November.
Huh.
And it has been ordered that it will be again listed after 4 weeks. But it almost 4 months is over. But
What is the matter? Urgency. What is the urgency?
actually, the third party is building the unauthorized on that property. So we want to stay that unauthorized construction. So that's why we have put an IA also.
Seventh May. Yes.
May I please, my lord? My lord, the petitioner before your lordship is my lord Kashmir Advocates Association, my lord. The main prayer in the present writ petition is my lord for the establishment of Bar Council in the UT of J&K.
Yes.
My lords, the matter was last listed on 31st of January. Your lordship has made returnable after 4 weeks, my lord. But the matter is not getting listed, my lord. The last date which was showing on the status is 17th of April. But no date is
Now no date is showing.
Yes, my lord.
All right. 7th May.
Obliged.
Yes.
May I please, madam? What is the contempt which I was trying to mention yesterday, Lordship?
Yes.
Well, in spite of a lordship action, husband is not paying the amount which is, and your lordship reiterated the order on 18th of February 2025. The matter was to be listed on 20th March. Unfortunately, the matter could not reach, and thereafter no date is there, Lordships.
All right. Today is 20. Second. 30th April.
30th of February. Please, my lord. Obliged, my lord.
Yeah.
This is a bail application. The petitioner is in prison for more than 5 years and charge is yet to be framed. In fact, my lord, the last 2-3
What is
occasions,
the offense?
UAPA, my lord.
UAP.
Yes,
And along with that?
that's all. No other offense.
No, there must be something, some background.
Predicate offense, something like that.
No, my lord. The
Basic
allegation.
offense is under the code, penal code or something.
No, my lord, the allegation is that he was a member of a proscribed
Organization.
But in fact, pleadings are complete. The last 2-3 times, my lord, it could not reach. And in a couple of occasions, the learned ASD sought for a passover and then the matter did not reach.
Very well.
My lord, it was tentatively listed for tomorrow.
Huh?
My lord, tentatively it was listed for tomorrow. I
But it
mean,
is not coming up to the list.
not coming up in the list, my lord. My lordship could consider it on Friday, my lord.
We'll have it on 30th.
My lord, high on the list, my lord, if I
It will come, don't worry.
My lord. The petitioner, when he was arrested, was only 20 years old. He's in prison for the last 5.5 years.
Must be doing something wrong. That is why he is inside.
My lord, it is my case that there is
Ah,
no
of
material.
course, everybody's case is that. Nobody says that I was wrong. That's all right.
High on the list, if my lordship may consider.
High on the list.
Yes.
The high on board.
All right.
Bail matters are normally listed high on board only.
Yeah. The last 3-4 occasions, my lord, unfortunately, it couldn't reach.
Yes.
But this was the matter which was listed on 4th of February.
Yes.
But thereafter it was supposed to come after 2 weeks. Because there is no date which is showing. This is a custodial torture matter. There is some urgency in the matter.
All right. 30th April.
I'm so grateful.
Yes. Huh? Come this side so that we can hear you. Microphone is there, no?
Milords, my husband has to come today as directed by your lordships.
Huh.
and he has to give the money to me. It might not reach because it is 35 minutes. That's why I was saying that.
If it doesn't read before lunch, then at 2 p.m.
Lordship,
Inform the other side also.
Lordship.
My lords, may I mention one contempt petition? It is an unlisted mentioning.
Unlisted mentioning is not permitted.
My lords, just listen 1 second. My lords, there was an order that should be uploaded, but it is delayed for some reason. And they, my senior mentioned it last week for correction of order. So that has not been uploaded yet. And
What order correction?
contempt petition. In,
Huh?
Delete का correction था मुझे पता है.
File करना है आपको.
Does in your lordship, there was an order passed by your lordship's bench. There was some correction in it, so my senior mentioned it for the correction. There was some direction to file an undertaking, so for the eviction, your lordship.
Huh.
That direction is given for 1 week. That 1 week is ending today, your lordship, but the corrected order is not uploaded yet. So that's why we are seeking permission to file that.
Uploaded. Why is it not uploaded? How much time will it take from?
One week is ending today, your lordship.
You prepared your undertaking.
Yes, your lordship.
Be ready. Give it to the registry. You will get the order during the course of the day.
Okay.
If you're not able to file it there, give it to the court master.
My lords, I'm mentioning maintenance matter. Actually, it's a maintenance matter. The lady is in a very bad
No,
state.
is it listed today?
No, my lords.
No unlisted mentioning.
My lords, it's a very bad situation. My
Bad
lords.
solution come through mentioning board.
My lords, can't be listed. It's a civil matter. It can't. We
Why?
can't circulate the letter for that.
Why can't you circulate the letter? Because what is the problem?
Because civil only criminal they are allowing.
No, there is nothing. You file an application for early listing, we will, that will be, on that you can mention.
Right. My lords. I'll do it. Obligation.
Let the registry notify this to the lawyer so that they know when to apply for mentioning and how to apply for mentioning. Okay, court master, inform the registry to issue a circular. Otherwise, we will have to pass a judicial order. Every day they come with this request. Huh.
Lord, please turn to page 531. It's 94 transactions, my lord, in 24.
One minute, Mr. There, let us open the item 11. Yes.
Please turn to my lord 531. There is a table I am relying upon.
1 minute.
Page 531.
531.
531.
Yes.
Now, my lord, the first FIR, if my lords may see, I got arrested on 16/8/2020 in an offence of 498A. Now, thereafter, my lord, since then, from 16/8/2020, I am in jail. Now, my lord, please see, then subsequently, while I was in judicial custody, my lord, number of offences got registered, dating back to 40 years, 50 years, 30 years. Now, please see, my lord, item 2, my lord. Item 2 is, the date of offence is 87. Then, my lord, the offence is 17/10/2020 after a delay of 33 years. My lord, last column, again 406/420. Now, the last column, bail granted by this Honorable Court on 25/11. The last column, my lord.
Yes.
Then, my lord, number 3, 2010-20. Now, kindly skip, my lord, and come to number 4, my lord.
Yes.
Now, number 4, 1991 transactions.
Yes.
My lord, after a delay of 29 years, 4/11/2020 FIR. Now, bail granted by this Honorable Court on 25/11. Now, my lord, likewise, please see now item 8, my lord.
Where is that order of 25/11?
Yes, my lord. I'll immediately point out. Now, only see first, my lord, 8, my lord. What I am trying to point out is this item 8.
Yes.
Now, please see, my lord, I got bail by this Honorable Court on 25/11 on the same day in column 2. 25/11/22, there is a fresh FIR. On the same day, my lord. In the afternoon, the order got dictated, and in the evening, there was an FIR. And the transaction is of 1982, after a delay of 40 years. Then, my lord, I was granted bail on 19/12/23 in this FIR. Now, please see item 9, my lord. On 19/12, the transactions of 96 after a delay of, and then this is the present FIR, and thereafter one more FIR, my lord, that is at 9, that is of, my lord, 9th of August 24, the transactions of 1980, my lord. I filed an anticipatory bail application, it got rejected by the High Court, and the other matter 11.1, my lord, is that matter. Now please see, my lord, 94 transaction, there is an allegation of 1994 that a permission of Mamlatdar was, my lord, forced, and this FIR got registered in 2023, my lord. These are all, my lord, documentary evidence case. The charge sheet is filed. My lord, I am in jail since 2020. And my lord, please see now, I'll take my lords to the FIR, and that is at page 159.
Yes.
Now, if my lords may see the date of the FIR, line 3, my lord, 19/12/2023. And then, my lord, column 3 occurrence is 96. This is the present FIR. Then kindly have a look. Now, please see, my lord, 161, reason of delay, my lord, para 8, column 8, my lord. Reasons for delay at 161. In reporting the complainant, in reporting, my lord, the complaint due to ill health of the complainant. So 27 years ill health of the complainant, this is the reason for delay, my lord. Now please see what the allegation is, that one order of conversion of land, my lord, of 1994 was forced. That's the allegation, my lord. Now, if my lords may see, there is a sale deed. The sale deed, my lord, dating back to 1996, wherein, my lord, that 94 order is, my lord, stated. Now, that sale deed of 96, it was never challenged. No suit filed till date. And this is for the first time, there is an FIR. And the man, my lord, who executed the sale deed, he died in 1998. These are all his heirs. So 94 allegation, 96 sale deed, 98 the man died, 2024 there is an FIR. And my lord, likewise, since August 20, my lord, I am in jail. I am in judicial custody. This is a case of documentary evidence, my lord. The investigation got completed.
Not completed.
Got completed, my lord. The charge sheet is filed.
Trial has begun.
Yes, my lord. It is before the concerned court.
No, trial has begun.
No, my lord. Trial has not begun. The charge is not framed
Charge is not
yet. Now, my lord, these are, my lord, all old transactions. And my lord, in other cases, I am on bail, except these two cases. Now, one more thing, my lord, they are relying upon the antecedents. Now, kindly have a look at page. Kindly have a look at page, my lord, 93, my lord.
Yes.
93 is an order, my lord, granting me bail in a different matter, my lord. The first matter, wherein they raise this point of antecedents, Now please see at 125 in the same order.
Bail order runs into 42 pages.
My lord, that again an SLP against that got dismissed, my lord. My lord, please have a look.
Yes.
Dina.
Can I have a copy?
Yes, we will come to page 125.
Now please see, my lord, 125 para 32.
It was some family issue. I didn't even press. Some family dispute.
That was 498 matter.
498A, but what I'm trying to say, please see para 32, my lord. These antecedents were dealt with.
Page 32.
Page para 32 at page 125.
Yes.
Now at 33, my lords may see, the issue of the past antecedents always become important, relevant. Now kindly just skip 5-6 lines. Now it is right time to cursorily look into the allegation made in the 6th FIR.
High Court order for this purpose.
The reason being, my lord, these antecedents were already dealt with by the High Court twice. An SLP which was preferred by them against that order, my lord, got dismissed, my lord. And now again, in every matter, they are going on those antecedents which I pointed out at page 531. Now they have come with 1 or 2 more, my lord, FIRs. Now they say those were of 2003. In those cases, the High Court has stayed, my lord, and that those investigations are stayed since, my lord, long back. So here, my lord, a case of documentary evidence, everything is under their control. The charge sheet is filed. And my lord, I am more than 70 years old.
When was the charge sheet filed?
My lord, charge sheet was filed 13/3/2024, my lord.
13/3.
Yes, my lord.
1 year back.
Yes, my lord.
More than a year.
Yes.
Why did you file 167(2)? If you say that you are in custody for 5 years and charge sheet is filed in 24.
No, my
No,
lord.
no, no. This FIR is a
In this case, my lord.
FIR is up.
So what is happening, my lord? In one case, I am arrested, then I am kept in jail for 5 years, and during that judicial custody, my lord, there are a number of such FIRs.
Right.
And my lord, those transactions are dating back to 40 years, 50 years, 30 years, my lord. That's my case. So in this case also, the charge sheet is filed. The investigation got concluded. It is before the court, my lord. The court may proceed, my lord. But
The solicitor is opposing him. Let us hear him.
very good. And the other matter, my lord,
Yes.
the 11.1.
What is that?
That is against an order of anticipatory bail. Again, my lord, the last case, my lord, in the
page
table.
531.
Page 531, my lord. There I filed an anticipatory bail relying upon this antecedents, my lord. My bail got
They
rejected.
have taken you in custody.
That has become
Yes, my lord. Yes, my lord. Yes, my lord. That
has
after
been arrested,
rejection-
it has become infectious. But let me show, my lord, the facts, which my learned friend, my lord, did not. obviously.
After rejection,
Wait, Mr. Mehta, let him complete, then we'll hear you.
my lord, after rejection of anticipatory bail by the High Court by reasoned order, my lord, they arrested me. I challenged it, my lord, but I also understand, my lord, the limitation. But the only thing is that these findings, my lord, may not come in my way of deciding a regular bail application.
Correct.
That would be on a different footing. At least that, my lords may say in the other matter.
Okay.
In this matter, I am for bail, my lord.
Very
Please.
Lord, your lordships are aware, my lord, my lord.
And in that matter, I'm sorry. I'm so sorry. I'm so sorry. In that matter, my lord, in this matter, my lord, the land is sold by the original owner
All right, we've heard you.
to a third party, my lord. And now they are saying,
1998. That's also you mentioned.
no, the heirs have now sold. They registered an FIR, then they sold the land, and they have come for a compromise. They came to the court that we don't have objection if they are released
I'm going
after
to-
selling of the land, my lord. This is what has happened. Please.
Yes.
Now, my lord, your lordships are aware. Lord, in Gujarat, dealings in land, my lord, is very frequent, my lord, but more frequent is criminally dealing with the lands, my lord. And the petitioner is the kingpin. He is the pioneer of this theory that this is how you can grab the lands, but nobody was coming forward despite having an evidence. My lord, please come to page 6 of the judgment. Page 6, my lord. of the judgment. My lord, somewhere 10th line from the top, forgery or cheating is committed. My lord, it starts with that. Yes. Forgery or cheating is committed by the applicant. The court has to consider the fact that applicant is used to camouflage land transactions, and considering the antecedent part of the applicant, this is not a case of simple land transaction. Considering the proclivity of the present application to grab the land, number of transactions under the guise of cooperative society or the firms, he has grabbed the lands, and many people have been duped. And one after another, after entire scam came to light, other people have gathered courage and started lodging complaints, and it is the duty of the state to look into the grievances raised by the complainant. Lord, there are people who are coming. Here the allegation is, Lord, my Lord Justice Nath would be aware, my Lord, just for my Lord Justice Mehta, Lord, in Gujarat, we have a system of old tenure and new tenure. If I am, my land is old tenure, I can transfer it to somebody. New tenure is a land given to me only for my use, my purpose, etc., etc. Agricultural land.
Can't be transferred.
Yes. Now, my lord, this gentleman forged an order of the collector, who is the authority empowered to transfer from new tenure to old tenure, and my lord, grabbed this land on the ground of that forged document, page 7, para 4.1. Even the applicant has forged power of attorney in the name of cooperative societies and in different parts of the state without paying consideration. Alleged incident took place and forged instruments in the name of office bearers including SC/ST community, and even the applicant influenced and threatened the witnesses. In case on hand, merely because the offence is not punishable with death sentence or life imprisonment, a triable by is not ground. Now please see how he tempers. I'll come to my lord, the Mamlatdar order being tempered, my lord. Even the applicant is threatening the witnessing from jail. Even during the pendency of bail application before the learned sessions judge, applicant filed the affidavit of siblings of legal heirs of deceased and stated that compromise took place when the said application came up for hearing on 1st August 24 at the time of said affidavit was filed. Thereafter, the original legal heirs of complainant came before the court and stated that they have not entered into any agreement or compromise with the applicant, and they have not settled the dispute with the complainant, and alleged affidavit was filed by the brother. Considering the potentiality of the applicant to influence witnesses, court should not let. My lord, now kindly come to, my lord, page 11, my lord. Page 10, bottom, I'll read, my lord.
Yes.
But third line. But it is needless to say that merely because the land transaction is mentioned for the year 96, but date of knowledge and one after another scheme of fictitious transactions surfaced and the FIR is registered. My lord, here also my learned friend said the delay in registering FIR, he pointed out one clause. But my lord, I will show, my lord, from the FIR, the heir says that we came to know immediately, some date is given, and therefore immediately we are filing this FIR. The issue is with regard to forgery of government record and order of government to convert the tenure of land. Herein the allegation is a forgery of government record is there, and said record is till date not available and or is yet to be recovered. The co-accused are out of reach. Now the submission on behalf of the applicant that as the investigation is over, no purpose would be served by keeping the applicant behind the bar requires consideration. But it is pertinent to note that applicant is having similar nature of 11 past antecedents, and applicant by adopting similar type of modus operandi has grabbed the lands, and in this regard, various complaints are filed. This court is conscious of the fact, etc., my lord. My lord, thereafter, my lord, the court refuses the bail. My lord, my respectful submission is, my lord, the antecedents really show the biodata of the petitioner, that he has been repeatedly doing it, and he was so powerful that nobody was coming forward to make allegations against him and requesting for investigation. Now that has happened. Lord, now he has lost even in the anticipatory bail in the next FIR. Lord, my respectful submission is, Lord, this would not be a case under 136. Lord, your lordships are aware, my lord, in a bail matter, Supreme Court, my lord, would rarely interfere, and the High Court would be the last arbiter. No, that's the judgment, my lord. Lord, at the most, my lord, your lordships may consider that let the trial be expedited. The charges are not framed because he is filing one application after the other. He wants to anyhow come out and do not face the trial. I have no difficulty in clubbing all matters together and trying it, my lord, together or independently the way accused wants. But, my lord, this would be, my lord, setting a very wrong precedent in my respectful submission and would encourage land grabbing. And in Gujarat, land grabbing by these modus operandi, my lord, was initiated by the petitioner. He is the pioneer of this novel way of grabbing lands, my lord. There are several widows, my lord, we have filed affidavit. I don't wish to go, my lord, take your lordship through that. Several widows' lands were, my lord, grabbed similarly. Some of them are even today not ready to come forward and, my lord, file FIRs. My lord, kindly, my lord.
Yes, you want to say something more?
No, the
Anything you want to?
94 my lord transaction. Lord 24 FIR, the delay explained saying that illegal. And my lord, please see the pattern. My lords may kindly have a look at 531. My lords have
Now,
seen
Mr.
it.
Mehta,
Yes, my lord.
you are
Crime never dies, my lord. Your lordship knows. My lord, merely because I committed a murder in some few years back, would not be a ground.
But I'll certainly face it, my lord. If
So, you are appearing for the state, right?
For the state.
Now, in how much time will you conclude the trial?
My lord, your lordships may direct. Your lordships may direct, my lord, I will feel bound by that. I will be bound by it, not feel. I am bound.
my lord, if the only allegation is 94 order, my lord, from and the 94 order is not available. That's the finding recorded by the.
Let there be one trial and it will be clear whether
No,
or
my
not you
lord,
are
please, no.
actually a land grabber or not.
No, absolutely, my lord.
Clarify
Therefore, my lord, it may be a trial, my lord, but please see.
3 months, 4 months.
No, my lord, please see. My lords, my lord, I'm on bail. My lord, only, my lord, please see. They are alleging.
What would be a reasonable time to conclude the trial?
My lord, that's.
We want to test
No,
whether you are actually
that's
involved in
apart,
fraud, forgery,
that's
and or not.
my lord, please appreciate.
If one trial be concluded.
No, my lord, please. The trial even otherwise can be concluded if I'm out, my lord. That's not the issue, my lord. The issue is, my lord,
there is a specific finding that.
No, my lord,
threatening witnesses is while remaining inside.
that's
Once
incorrect.
they come out,
My
it
lord,
will become very difficult.
even reading the High Court order, my lord, it's please see, my lord, what has happened here. Kindly have a look. I'll give 3 dates, my lord.
What would be a reasonable time?
Lord, I'll give 3 dates. Lord. Kindly, my lord, kindly bear with me.
Charge sheet?
Lord,
16 months.
16 witnesses. I'm only saying, my lord, please, my lord, please see. 14/3/24.
Charge sheet is filed?
No, my lord. I'm saying the FIR got registered, then he sold the land, and that too in around, my lord, 7-8 crores.
And
No, that to
94,
whom that also we are investigating. Maybe,
my lord, it's
maybe
my lord,
your own company.
kindly see, my lord, and one more thing.
My apologies.
Gildale, keep your microphone off.
My lord, all 16 witnesses, they are, my lord, government witnesses, except one. Now, please see, only one thing, my lords may see. In the sale deed, which they are referring to, that 94 order, my lord, which is at page 33, and at 45, my lords may see, it is the seller. My lord, that would be its writing on the wall.
Right.
If my lords are, my lord, sending me to trial, my lord,
We have heard
that is.
Shri I.H. Syed, learned senior counsel appearing for the petitioner, and Shri Tushar Mehta, learned solicitor general appearing for the respondent state of Gujarat. Full stop. We have previously impugned order passed by the High Court rejecting the prayer for bail of the petitioner, which is quite in detail and has considered all
My
the
lord, may,
arguments.
if my lords. I'm sorry.
Considered all the arguments raised before it and before us. Full stop. Specific finding has been recorded that of specific finding has been recorded. Then the High Court notes that the petitioner, while inside jail, has been threatening the witnesses, and there is likelihood that in case he is released on bail, he would further tamper and with the evidence and threaten the witnesses. Full stop. It has been, next paragraph, it has been informed that the police report under section 173(2) CRPC was submitted way back in March 2024. However, charges have still not been framed. Full stop. Mr. Mehta has submitted that any reasonable time fixed by this court, the trial court, for the trial court to conclude the trial, the prosecution would extend all cooperation and lead the 16 witnesses maximum as mentioned in the charge sheet. Let me complete the order, Mr. Although Mr. Sayed has resisted the submission of Mr. Mehta for direction to the trial court to decide, conclude the trial, we feel, considering the nature of antecedents and repeated allegations of land grabbing by forgery, etc., of government records, we feel that at least in one trial it should be tested whether or not the petitioner is actually guilty or not. Full stop. Considering the facts and circumstances of the case, then we do not feel fit to grant bail to the petitioner. However, we direct the trial court to conclude the trial within 4 months. The prosecution and the defense would not be seeking adjournments and would extend all cooperation in the conclusion of the trial. Full stop. With the aforesaid observation, petition stands disposed of.
Immensely grateful.
And
Date fixed in the trial
25th
of April.
of April.
Then so,
now only thing,
copy of this order will be placed before the trial
only thing, my lord.
on the next date fixed, which is stated to be 25th April 2025. This order को आज ही upload करा दीजिएगा.
My lord, only thing.
हाँ, 11.1 में लिख लीजिए. This is a petition arising out of an order passed by the High Court rejecting the prayer for anticipatory bail of the petitioner. It has been informed that during the pendency of this petition, the petitioner has been taken into custody. And as such, the petitioner would be at liberty to apply for regular bail. Full stop. Mr. Sayed has submitted that any observations made in the impugned order may not come in the way of the consideration of the regular bail application that may be moved by the petitioner. We order accordingly.
Only thing is, my lord, there are 18 witnesses,
16
witnesses, and my lord, only one witness, the complainant,
Yes.
is the private person, otherwise all official witnesses.
Oh.
I am only requesting, if once after the complainant,
In case the trial is not concluded within a period of 4 months as directed above, for no fault attributable to the petitioner, it would be open for the petitioner to revive his prayer for bail.
here, my lord, in the Supreme Court.
Wherever you are free.
Revive my bail in the,
But now every good thing-
because what will happen is,
That's all right. Before this court, you come here.
and only thing, my lord, one more.
And only Mr. Sayed will
Please,
come to argue
Mr.
this matter,
Sayed,
nobody
now
else.
Adam-
If any other counsel comes, we will dismiss it. Yes, next.
Okay.
Great.
Please, Manoj. Manoj, this is for regular bail. Manoj, they were arrested in November 7th, 7th November. Wait.
Ramanuj.
Yes, Manoj.
Yes.
Manoj, this is for regular bail. They were arrested on 7th of November 24. Manoj, the challan has been filed in December. One witness has been examined. The complainant, Manoj.
And you are under 306.
Yes, Manoj. No, 407.
407.
Breach and theft.
IPC 407.
Oh.
It's trial by magistrate.
Passport purpose.
अभी PS तो मुझे registry
Well, there are total of 11 witnesses.
all right.
Only 3.
How long has he been inside?
Minus he has been inside for 5 months, 5 to 6
5.5
months. Minus
And what is the arrest offense?
minus the offense is that he has stolen
Huh.
wire rod bundles from
What
the
is
company.
maximum punishment for this?
7 years, minus.
Seven-
7 years.
Then-
Whereas my only concern here is that the petitioners are not residents of Rajasthan. One of the petitioners is a resident.
Insist for local service before the magistrate.
Very well, Manoj.
I appear on behalf of the complainant.
Get them fixed before the trial court, the conditions. लिखिए bail granted.
I appear on behalf of the complainant.
Very well.
There is
You
no
copy,
recovery.
of course, the
There
grant.
is no recovery has been made till now, Millards, and one
No,
of the
but-
one of the
but
accused.
6 months if the police has not been able to make recoveries,
Well,
the
it's-
police ask for remand.
Millards, the real apprehension is because one of them is.
The agency asked for a remand. Next, bail granted. Prosecution would be at liberty to insist before the trial court. We would request before the trial court for imposing stringent conditions.
Obliged.
Very well.
Lordship, I filed this matter before I engaged a senior advocate.
Yes,
There's
Mr.
a-
Tony.
There is a pending SLP,
Huh?
311/24.
Hmm.
So now I've been advised by the senior advocate to, he will cover these,
Call the court martial.
he will cover these.
Martial, we will send him to ARA straight away.
Sir, listen, sir, I'm withdrawing the matter because.
See, we are sending you straight to Tihar from here. You know,
My lord, I'm withdrawing the matter.
why did you even file it?
I'm extremely sorry. I'm advised by the senior advocate.
You are advised by the senior counsel. Please name the senior counsel.
The senior counsel, Mr.
Sir,
I'm
Please
withdrawing,
name the
but
senior
I'm,
please name the senior counsel.
but
Mr.
sir,
Shahid
yes,
Prasad
if it is,
advise you.
it is my,
Mr. Videsh Gupta advise you.
no.
Which senior
He
counsel
did not
advise you?
advise me to file it, sir. I filed it, but now I'm
Mr.
withdrawing.
Vidya Parekh advise you.
I'm withdrawing it on the recommendation, sir. It is my fault. I'm withdrawing.
Why did you even file it?
It is my fault, sir. I'm withdrawing it, sir.
How much cost should we impose?
No cost, my lord.
Why not?
I'm requesting it is. I was
100%
not aware.
cost.
My lord, please, it is my request because,
Firstly, you spoiled the environment of this court, which is a very friendly environment.
sir.
You have been capable of that.
I did not do that.
Previous date also you did, and today also you did.
My lord, this is not my intent at all, my lord.
That's your total intention.
I'm here for justice, my lord.
So, and then you have been wasting all this time.
No,
Now, how much time with the registry in processing your petition?
I'm withdrawing. I'm withdrawing.
How much cost should we impose?
No cost, please, sir, because I'm here because I'm facing certain issues, sir. No cost may be imposed. It is my humble request.
Because the petitioner who is an advocate
Sir, it is my request to not please include these comments. It will affect my practice.
and
So,
understands the law and the nuances of law has still got the guts to file this petition under Article 32 of the petition, Constitution of India. He has not only wasted the valuable time of this court, but also of the registry, and has spoiled the entire environment of this court. On previous occasions also, the petitioner was advised to mend his ways. Full stop.
sir,
Today,
but
uh,
sir, but I'm complying with the
you
other
have
orders, sir.
also perused the reliefs claimed in the petition. Which are which a prudent lawyer of basic knowledge would not claim under Article 32 of the Constitution. But still, Mr. Todi, who has the registration, the Bar Council, since
So it's very recent, sir. That's why I
Yes, yes.
the
How long,
indulgence
when
of
did
the
you pass
court.
out?
It's 2022 only,
Ah,
sir.
last 3 years, and has been conducting his cases in all courts, including this court. Unlisted made all those players. Full stop. Today, when the matter is the allegations made in the petition and the relief claim are totally frivolous and malicious. Full stop. Today, when the matter is taken up, Mr. Todi, the petitioner, stated that he may be permitted to withdraw this petition. Full stop. If we allow simplicity of withdrawal of such petitions, it would be sending a wrong message. The seconds to file any frivolous petition and then get away with it after wasting the time of the court. Full stop. Accordingly, we dismiss this petition with cost of rupees 5 lakhs to be deposited.
Lordship, some indulgence
For
will be
the-
shown. This, I request to reduce the cost, my lord. This will be too much for me.
For this, the National Legal Services Authority. Within 4 weeks from today. Proof of such deposit may be filed before the registry within 6 weeks. Full stop. The office will list this matter before this court in case proof of deposit is not filed within the time indicated above. Next case.
May I crave my lord's indulgence? Item 43 is connected. He's the husband in the other matter.
When it's called out, we'll take up.
Grateful. He has not complied with the directions of this.
When the matter is called out.
I am grateful.
Yes, now item number 14.
Lordships may recall this is a matter with regard.
Rehabilitation issue, my lords have listed.
Yeah.
My lords have appointed that committee
That is for the forest.
Yes.
forest
So this
and for rehabilitation.
Yes,
Yeah, right.
we have
Yes, sir.
separate both the.
Separate.
That's correct. Yes. Lordships meanwhile passed an order protecting the biodiversity because it was a very important, my lord, area. And the order is certainly, my lord, was required even earlier because it was declared much earlier in 2018, my lord, notified. My lord, as I said, my lord, in the beginning itself, my concern is only about the rehabilitation issue. I'm not saying I'm a forest dweller. I'm not going for the time being into the other questions, my lord, which may be raised before the VRS, etc. Now, my lord, on the issue of RNR, lordships may come to the judgment at page 104. And then after that, my lord, I'll take your lordships to the policy of the state.
As per the state claims that they have already taken steps for rehabilitation. What remains as per you?
Yeah, my lord.
Can you
The
shortlist
question.
what is pending?
Now, the
And then
question.
what is your right to receive those measures?
Yeah, my lord, that's correct.
Yes. You are simply workers of the tree estate. That's it, nothing beyond that.
Now, my lord,
Yes.
which I put in my additional affidavit also. When we look at, my lord, the rehabilitation RNR developed as part of Article 21 of the Constitution, because in Sardar Sarovar, the question was that whether you give compensation in lieu of the acquisition, whether that is enough, because people are displaced. So they said that is not enough. My lord, I am coming, my lord.
The owners of those.
I am coming to that, my lord. I am coming to that. I am conscious of that part. What I am trying to say is, in Terry it happened, and thereafter, my lord, the national rehabilitation policy came, which I am pointing out to
You are still not
answering.
answering the question put by the court.
What is
that? What further that you require, which the state is not offering you.
Yes, my lord.
And your entitlement to that.
Correct.
That is the question we put
Correct,
to
my
you.
lord. Correct.
So
I am.
answer
What
that
I am
question
saying is
one or two sentences, and then you can
Yeah, correct.
elaborate on the background and the
Very-
reasons and everything.
Lordships are right.
I just want a simple state answer. A, B, C, D. This is what you are entitled to, which the state is not providing.
Yeah.
And the basis for your entitlement, you tell us that.
My lord, that's
Yes.
correct. My lord, my
Otherwise, you will dismiss this matter now. And keep the
lordships will
Because the state says that it is
lordships
not-
will not
the
discuss
state
the
says
matter. I know.
more than what you are entitled to otherwise.
And
You are claiming.
my lord, we have also filed the affidavit.
Well, when lordships are putting a question to me, I know lordships are putting a question to me. Not that because there is a compassion inside, but that not that it will be dismissed just like that. My lord, the answer is this: that these people have been living there for two, three generations. That's something which has been acknowledged. Now, the moment, my lord, they could have continued for more time because the lease is for a 2028 or something, they could have continued, but meanwhile this has happened. The submission is this, my lord, when we talk about rehabilitation, then meanwhile, my lord, which High Court also pointed out, a policy could have been evolved that these people will be uprooted from this place and will go to the other place within a given time. Because what happens is, my lord, some people are living there for, say, my lord, 50 years, 60 years, or 70 years, generations as it doesn't mention. When you uproot them, where do they go? Ultimately, they require, my lord, in terms of living a temporary accommodation and thereafter permanent accommodation.
Now,
These people,
whether you have actually provided the facilities as per your scheme or not?
Yes.
No.
So far, 197 people have been given. 247 applications were received.
247.
247 out of 534. 247 applications were received. 197 orders have been passed and they have been handed over. As far as those remaining 50, they are not under the scheme. They have to provide their Aadhaar card and other documents. They are not providing. So we are in touch. In fact, we are very proactively approaching them and requesting them that please provide so that we can give you the alternative.
No.
And all the alternative accommodation is available.
in the order that my condition, which I said, that the encroachers who are given, my lord, a better kind of a deal, in the sense, and lordships wanted me to put that particular policy on record, which I put on record. I want to show to your lordships one thing, and my argument is very simple because, my lord, I must say that I argued all those matters for decades, my lord, and therefore I am aware of the development of law of rehabilitation. And my lord, we actually
listen to what we propose to do.
Yes, ma'am.
We will hear this matter at considerable length.
Not,
we
my lord,
will grant leave, and in the meantime, we will direct the state to continue to implement the scheme of rehabilitation, which they have already started, and according to them, 197 orders have been passed, where the
I have, my lord, some problem. I have some problem.
Documents,
I have some problem, my lord. I put it to
you
ourselves.
get the same benefit.
My lord, the question
If you succeed, whatever more is entitlement, your entitlement.
No. Not entitlement, my lord. I am not talking
There are
about
only
entitlement.
84 families in the.
Mr. Just wait. I am not talking of entitlement. I am talking of the sensitivity which it requires. And sensitivity is, my lord, this, that people who are living inside, they were getting medical benefits, they were getting, my lord, there was a school, etc. There was an employment, they were getting only 450 rupees. Now the scheme which, my lord, they have mentioned, the High Court has mentioned, is that people will be provided flats. And I'll show to your lordships, my lord, what the direction which have been given. I'll come to the direction and show to your lordships whether it fulfills the requirement. What about their education? What about their medical needs? What about, my lord, the drinking water? What about so many other things which, my lord, which are available to them? Which the national policy, which, my lord, the new Land Acquisition Act provides RNR, which, my lord, oh, I'm so sorry.
Kindly see 28th February affidavit of the state on RNR policy, and we compared this.
Let me argue now. Which, my lord, which is provided, my lord, only 1 second, which is provided under, my lord.
Parties are at liberty to complete their pleadings and file additional documents in the meantime. In the meantime, the state would continue to implement the prevailing scheme.
Yes, my lord.
Under which a large number of occupants have already been exempted the benefits.
Yes.
And the remaining would also be entitled to the same benefits. If ultimately
there are 84 families which are not vacating out of 534, 84 have not vacated. They should vacate, my lord.
The appellants succeed, whatever further entitlement is due to them
will nothing.
But those 84 must vacate, my lord. Otherwise,
well, Mr. Tiwari, I'm here. Oh, no, even otherwise.
One is, my lord, rehabilitation,
Your Lordship
something
might remember,
which
my
has
lord,
to take place
collateral-
immediately
collateral
after
matter.
so many years, my lord, it will have no value. That's
Lord-
number one. Number two is, my lord, if I go to the directions, because lordship says the directions will be implemented, kindly just look at, my lord, one thing, only one point. Look at the directions which.
One of your SLPs has been dismissed.
Yes, my lord.
Despite
No,
the
that is
entertaining-
no, that was in Forest Well, my lord. They were
No, no,
claiming
no.
under the FRA. I am not on that. I came on the beginning itself said I am not on that. My lord, the rehabilitation is on Article 21. It has to be immediate. It cannot be, my lord, delayed. I am not, my lord. My lord, may I lordship, my lord?
It is as an interim order in any manner, and the directions of the High Court would be fully complied with by the state as.
May I show only one?
Yes, my lord.
May I show only one
issue,
point,
my
my lord?
There's one
I
issue.
will not
lord.
argue beyond that.
I
May I
don't
show
know.
one point, your lordship?
Gonzalez, you
Only one
say
point.
something.
Something, my lord. Learned
I'm not
agent
able
wants
to
submit.
outshout
second,
the virtual court. My lord, there's one issue, my lord. Your lordship is the.
That's a disadvantage, Mr. Advocate General, of appearing through video conferencing.
My apologies, my lord.
You should have traveled, taken a flight to Delhi. Why don't you come? You're sitting in Tamil Nadu and you want to.
Lord, I would love to come there and address your lordship, my lord, but last few days of the High Court, we closed next week, my lord, for the summer, which is why there's some pressure of work on me. Otherwise, I would have loved to be there for today, for the hearing. But I just wanted to say one thing, my lord.
Yes.
My lord, your lordship remembers, my lord, a couple of weeks back, your lordship's bench has passed a collateral order on the environment issue, where the Solicitor General appeared. Your lordship has directed us to cooperate with the central government and the Central Environment Agency. Ensure protection of the tiger reserve as well as the forest.
Yes.
For that to happen, these persons have to vacate from that premises, my lord. Right now,
That's why we are
clarifying that we are not passing any interim
Yes, ma'am.
order, and
Yes.
the pendency of this appeal would not be interpreted in any
Grateful
manner to
to
be
My lord,
impediment in the
Grateful to your lordship.
implementation
Yes.
of your schemes and the High Court order.
My lord, I said so.
Much
that
obliged.
will- because we are not in the way, my lord. There is no question. I said so in the beginning. Only one point, my lord, lordship, permit me only one point. Just look at 110.
All right, we'll look at 110
Yes.
for your satisfaction.
My lord, there are,
We have
yes,
to do
yes, my
that.
lord, kindly, my lord.
Yes, Mr. Parekh.
I'm grateful. There are 534 families. Now, lordship will find
Yes.
in para 1, the direction is about giving them 240 homes, my lord.
Yes.
240 para 2. 240 in, my lord, Tamil Nadu Habitat Development at Papan Gulam. And then 150 apartments in Rediarpatti. Now 144 are left out. For them, the direction is in B.
Yes.
In order to provide housing for remaining homeless and resettled workers, the state government will also make sure that additional measures are done to construct similar set of homes. 144 persons, my lord. One can understand that if they are providing, they may provide probably in a week or 2 weeks, whatever. What about the 144 families where they will go? There should be some.
Under direction to provide it.
No, but then, my lord, it is. What has been mentioned will also make sure. Now the question is if there is a
We
time
have
bound.
said that they will comply with
No,
the
my lord.
directions of the High Court.
If there is a time bound, there should be a time bound thing, my lord. Everything is essence. Time is, my lord,
All
rehabilitation.
right, next case.
My lordships are not directing that they should provide them in within a reasonable
They
time.
will definitely provide without that.
Yes,
If
ma'am.
they don't provide and they throw you out,
Yeah.
come here.
No, my lord, how I can, because
You
lordships
always
are.
come back to us. Yes,
No,
yes.
how can I?
No.
Deep burial sites, I don't want to. They will,
Item
they will deal now.
52.
They will not do any sense.
Yes.
Well, it's in this. There are
I
two
thought
matters.
lordships will hear me on rehabilitation in a detailed way, my lord,
We'll
but
hear
tonight
you
will
in
not.
Well, there are two matters.
Well,
The
in item
first
52,
matter
I'm
in
seeking
item
for a
52,
passover.
Your lordship has already granted stay.
Seeking for a passover, my lord.
May I just tell your
Led by the
lordship?
learned Solicitor General.
Solicitor General.
He's on his legs in another court. He'll be here in another
Well,
minute.
may I make a suggestion?
Call him immediately.
In item 52, there is already a stay minutes and we'll be filing a reply. In item 52.1, which was mentioned last week, your lordship tagged it with this matter. Notice has not been issued. They may give us a copy. The matter is posted in the Honorable High Court on the 7th of March. Your lordship may keep it before that on the 6th. We'll file a response minutes. I'm carrying some photographs and documents.
Wait. Let the solicitor come.
In item 52, your lordship had, that is the case of that veranda in the High Court. Your lordship had asked me to assist. Now, in that case, what happened? There are these orders which I must point out.
You are with the Chandigarh administration or with the High Court?
I am with the person who says no tree will be cut,
and no green will be concreted. I am with that person. And fortunately for me, this time the administration is on the right side. And so we are here.
You have
But
administration, not with the High Court.
But administration is saying,
I'll take my submission.
administration is saying,
You
now,
have to change the
High Court has said something. Please see,
Perceived bias.
please see this order. No, this is only the truth, my lord. Otherwise, I am always fighting the administration for Chandigarh, my lord. Just please see this order.
Putting the administration in a wrong case.
Just please see this order, my lord. Construction of veranda in front of courtroom.
You are appealing for the High Court.
I'm appealing for the High Court.
Please see this order.
For one, Mr. Gupta is on the right side.
All right. But still I'll try to assist your lordships to reach the right conclusion.
Yes.
Now, this order was passed, my lord. What happened that after these two orders were passed by the High Court for veranda, the Bar Council of Punjab and Haryana moved an application for impletement, and they moved an application for recalling of these orders, saying that
Too much. Bar Council is not.
no, just
not to interfere in
just see what
system of High
the
Court.
just see what the
Yes,
court
serious reservation.
just see what the court says.
So I think-
I'm not one way or the other, my lord. Your lordship may take any view. Just see. In this respect, it is informed petition for special leave is likely to come up before the Apex Court for hearing on 28 January. Learned Counsel appearing for the newly impleaded respondent for that is Bar Association, not Bar Council, Bar Association of Punjab and Haryana has made an application for recalling of the orders passed by this court containing direction for construction of veranda in front of courtroom 1, issue of contempt notice against chief engineer. Court is of the considered view the factum may be brought to the notice of the Apex Court which is seized of the matter. Only thereafter some decision can be taken by this court on the said application. So therefore, I'm bringing this to your lordship's notice, my lord. This is what the court had said, and that application remains pending.
May I just tell your lordship what this issue is, Malat?
Yes.
May I just hand over two photographs? Mr. Courtmaster, please. And is it Malat's?
Mr. Patwalia would be having a first-hand information. He doesn't need the photograph.
But
No,
Malat,
I-
I'm handing over
I-
copies
I have
anyway.
lived all my life there, my
You
lord.
also
This,
live
according
No, Malat, I've been here, Malat.
according to
I've been here assisting your lordship, but Malat.
according to me,
And if he doesn't mind, Malat, I'll make my submission on
this
this.
is not
Now, Malat,
necessary at all.
Malat, this first photograph
Yes.
is of court 1.
Yes.
First photograph is the outside of court 1. Your lordship will find there are lots of lawyers, etc., all over here. Now just come straight away to the last picture, page 4. This is, Malat, the picture of court 2 to 9.
Right.
Court 2 to 9. Now your lordship sees, Malat, court 2 to 9, which has the same facade, has a little covering, Malat, which is there.
Yes, shelter.
Shelter.
Covered veranda.
Covered veranda, that's all. And this is there outside court 2 to 9. I have been there enough number of times to know.
When was this constructed?
This was constructed years ago.
It was constructed when the High Court was constructed. There was a proposal to.
If you don't mind, I'm
just
not.
1 minute. I'm
No,
asking a
it's
question.
not adversary. The question is put to me.
So this at that time there was a drawing. The Chief Justice at the time declined the drawing. There is now no drawing as to how this is to happen. This is a heritage building with a World Heritage status. So all that the administration is saying is, let us get approvals and we will do it. That's all.
I don't know if the administration is saying that. I'm just saying, Malat, in the first picture, the Honorable High Court has, Malat, noted that not only do the lawyers standing and waiting there have to face extreme vagaries of nature, of heat and rain, rainwater enters from the door also, Malat, if there's a strong breeze. And they just want a little covering there, like before court 2 to 9, which have absolutely the same facade. That's all it is.
Patwalia, we'll let you know now first-hand information. Rajasthan High Court new building, one of the former Chief Justices invited the lawyers to have a discussion on where the land should be selected. That was in 2003. Immediately protests erupted. Finally, we could locate a land. 2007, because of the resistance of the association split. 2007, there was a foundation ceremony in which Honorable CJI, Justice Balasubramanian was there. The lawyers showed him black flags. But the project got delayed. Ultimately, it could be commenced in 2013. And finally, in 2019, we had a new building at the location which should have been approved right there in 2003. And after that building has been set up, the lawyers said that this should have happened 25 years ago. That is the result of the lawyers objecting.
So
the administration of the buildings is not the task of the lawyer.
That is not the tradition of Punjab and Haryana High Court. That is not the tradition of our bar, and we don't oppose for the sake of opposing. But I'm
looking to the situation.
It's not a building. It's a heritage structure, and therefore. So, my lord, let him file his counter. Let him file his counter, my lord. We will assist.
let Mr. Mehta come, we will.
Yes.
Take a
Then,
call.
my lord, can I request for to be kept it on Friday or the next week?
My lord, it has come up late at night. I also would request, my lord, let it come up on a Friday or next.
First, let Mr. Mehta come
All
and
right,
address.
let him come.
If we are convinced, we will call upon the counter, and if we are not convinced, we will dispose of these matters today itself. Finished.
All right.
Let Mr. Mehta come.
I'm a Micus at 2 o'clock in the matter. Just kindly accommodate me for a bit.
No, as soon as Mr. Mehta is here, both of you are here, we will take up the matter. You can coordinate with Mr. Mehta. Yes.
So it's only this little covering here, just to let Lloyd stand in shade, my lord.
The issue, my lord, in fact, I would also submit, my lord. Let it come up after a couple of days because I have not read the file. In fact, only in the morning I was told this matter has come up. That's right. That's right. But I would, yes, I would.
Require your assistance
All right.
further.
All right.
Why should you seek an agenda?
All right. No problem. All right.
Picture can say 1,000 words, my lord. More than the counter, the picture.
Before Mr. Patwala comes back, he will. Otherwise, see, he is already turned.
The sequence is.
Sorry?
53 was for settlement by the secretary.
We will take it up. Wait. 54.
55.
What is 55?
My lord, this is an early hearing application. My lord, your lordship.
Early hearing application, we will allow. What date do you want?
My lord, today onwards, any day that's your lordship, that's convenient to your lordship.
You tell us.
This week, my lord, this Thursday or next Thursday.
It's a appeal?
Yes, my lord. Your lordship has granted leave and expedited the matter and directed the matter should be listed after 6 months. 6 months are over. It was now more than that. And my lord.
So we can have it on 1st May?
1st May.
First. IE for early hearing allowed. This the appeal on 1st May.
Grateful.
तो 53 कॉल कर दिया सेटलमेंट हो गया है दोनों पार्ट बोथ साइड हियर
Yes, yes.
Please, ma'am.
We mentioned yesterday, my lord, in terms of the settlement.
in terms of settlement. Settlement has been placed on record
Please, this is page 3.
by an IA.
That's right, ma'am. This is a joint IA filed by both sides, ma'am.
Joint application.
Page 7 is in Hindi, ma'am. The settlement.
IA is 74956. No. Yes.
And it's 62021.
62021.
Please, ma'am.
All right. Hi, that's also there. They uploaded a copy of the compromise agreement. So what order do you want today?
And it's page 3, my lords. We have proposed a draft order, subject to my lord's kind consideration that order may be passed. This, the disputed property was decided to be sold to 2 people, my lords, and we'll be sharing the proceeds.
Party hearing have the mill cap. Yes, sir. It's been uploaded also.
I have a physical copy in case required.
Hey, share. Party have, last but one thing. Parties herein have amicably agreed to settle all their disputes. Petition either. Order pardon. Settle all their disputes and sell the suit property and divide equally the proceeds thereof. Whereafter neither side is left with any claim toward the other and all their disputes herein are over and they shall remain bound with this settlement forever. Terms settlement takers also all parties in the agreement will be considered. So the property to she so and so. Whether it's thereof, there remains no dispute pending. To say all this in the order.
Well, it's a
We will say
difficult.
that as per the settlement, the parties shall abide by it. Finish. Decree be drawn accordingly. In terms of the settlement.
That would be.
Yes. Decree be drawn in terms of.
That will work for.
Look here. IS 2021 of 2025 is a joint application filed by the parties under Article 142 of the Constitution of India, read with Order 23, Rule 3 CPC, for passing a consent decree in terms of the settlement agreement dated 20th December 2024. Full stop. Having heard the council, we allow the IA and the suit shall stand decided in terms of the settlement decree be drawn accordingly, and the settlement agreement shall form part of the decree. Parties to abide by the same. End of the matter. Yes. It's been disposed of accordingly. Petition है appeal है क्या? Appeal है.
My lord, this matter is related to the pensionary benefits and the other benefits of the petitioner.
One. Item number 1.
He had already served 32 years, but today morning, my lord, my friend has showed me some few documents which shows that some benefits have been given by the department. The document has not been given to me, even it's not a part of the counter record.
What do you want? You want time?
I want time, and if they pass the record, I will check it, my
The
lord.
circular on which you rely upon doesn't talk of pensionary benefits, it only talks of salary and areas for the particular period. So how can you take pension under that circular?
My lord,
And then your suit was after how much delay?
My lord, there were 2 suits, my lord.
Yes.
That there is a recurring loss. So that delay does not apply. That I will show you, my lords.
Come to that circular straight away.
If they want to give you, let them give you. Why should we keep this matter pending unnecessarily?
My lord,
When we are convinced that the High Court order does not suffer from any adversity.
I am not aware about that, my lord.
Whatever
I'll just verify that. I'll come back to that.
That has already been given, my lord.
In terms of the circular?
No.
Or even the pensionary benefits have been given?
No, my lord, it was
Retirement benefits have been given?
No, my lord, it was not
There
given.
are
Even
only
I'm not
2
getting
agreements
pension.
which we stopped. He has challenged only by way of suit for declaration at that time only. And that were challenged under the rule only.
My lord, I have served already 32 years. I am not getting pension, my lord, after that.
Not entitled to pension, you will not get it.
My lord, I am entitled. My lord, I'll show that, my lord. The judgment, even the charge order was set aside, and my suit was dismissed only on the ground of delay, and that delay does not apply to this because there's a recurring cost.
All right, tell us under what provision were you entitled to receive pension?
My lord, I'll come on that point, my lord. Because
Tell us please, the matter is listed at serial number 1.
my lord,
Come to the order of the High Court straight away.
my lord, the High Court has only discussed that the suit was dismissed on the ground of delay, my lord.
You retired in 2003.
My lord.
When was the suit filed?
It's filed in 2005, my lord.
Yes.
So it's within limitation, my lord. And why, my lord? Because
what is the prayer in your suit? Let us see.
My lord.
Right away.
My lord, page number.
Only for increment, that's all. Where is the question of pension and anything?
My lord, it was, my lord, in the suit I was requested, the order passed by the charge order was not, it's a void order. Therefore, in view of to set aside that order as well as for the pension.
Order stopping 2 increments was only challenged.
Yes, sir.
In the suit.
That was the order passed in 1997.
Yes, my lord.
Therefore, the suit was dismissed on the ground of delay.
Yes, more than 3 years after the expiry.
My lord,
nothing more.
Just give me a today's 1 week, my lord.
Why?
My lord, all to verify all these things, my lord.
All right, dismiss. Next case.
My lord,
no.
My lord, there is a pensionary benefits also.
Very well. Next case.
The sole respondent has passed away in this matter. We have filed application to bring on record.
First, let us see what is there in your case.
Yes, sir.
Is there any merit in your petition or not?
Yes, my lords.
There is.
My lords, there is, but as per the procedure, we'll have to bring on record the LRs first. That is why
No,
we
you
have.
can dismiss it without bringing the LRs. Why do you need to wait for the LRs to dismiss
We are asking for pension, right?
No, my lords, we are not asking for. We are appearing for the bank. The respondent was asking for the pension on the basis of a circular, which granted only revision in pay.
That's right. That's right. The circular is reproduced.
Yes, my lords.
Yes. That doesn't speak about the pension.
Pension.
You are appearing for?
My lord, I'm appearing on behalf of the respondent.
The respondent has passed away. You present the heirs?
My lord, I represent the heirs.
Have you filed the wakalnama?
No, my lord.
Then you file the wakalnama, we'll allow the implement, the substitution. That's all that you want.
Yes, my lords. My lords, they were appearing last time also. They have filed
We have not filed the wakalatnama on behalf of the heirs.
Of the heirs.
for name the way. Yes, my lord.
We have not filed the wakalatnama.
Yes,
Have you filed substitution application?
Yes, my lords, we have filed 4
Allow
applications.
the DJ and grant a week's time to the respondent to file the Vakaratnama on behalf of the legal aid.
I'll file.
List again on next Tuesday. Come ready with the matter.
And for the wife, yesterday has uploaded the statement of asset and liability, and my client also has sent me the affidavit. You can give me 2 days, I will upload it.
Well,
2 days.
on the request of counsel for the petitioner list after?
After 1 week.
After a week. Next.
In item 4 mallards, I am for the petition mallards. I am for the very limited purpose mallards. Mallards, the observation made by the lender single in the writ petition mallards. I am just only for those observations mallards, because mallards in counter affidavit they have already admitted, respondent has already admitted that the closure report has already been filed in the criminal case mallards. In respect of mallards, just kindly see the page number 74 in that. It's a single judge order mallards. Page number 70, para 50 mallards. In respect of criminal FIRs mallards, some observation has been made in the FIR in the order mallards. The only those observations para 50 mallards.
1 minute. Page
70, para 50 mallards. CWP order mallards.
Page 70, yes.
70, para 50 mallards.
Huh?
Mallards, the surprisingly not only the respondent has given the additional charge of the sad post respective of the specific bar as provided in the clause 1 of so and so, but the respondent filing misleading and vague returns. Right, this is clear that respondent was not admitted to be given the current charge of the post subdivision Morena. Instead, he was given the said charge or so and so OIC. As stand has also taken by the respondent number 124 in their return regarding the local posting officer. Therefore, this court thinks appropriate to consider the caution also. It made clear that this caution is not directly involved in the present case, but it is cropped because the specific stand taken by the respondent number 4. My lord, respondent number 124 and has taken a stand that some FIR has been filed against me, my lords. This is
respondent number 5.
My lords, before the Honorable High Court, I was respondent number 5, my lords. In particular case, my lords, the closure report has already been filed. Just kindly see the counter affidavit.
At that point of time, it was pending.
At that time, it was pending, my lords, but at present, my lords, in the future, my lords, in future, it may prejudice the rights of the petitioner, my lords. Just kindly observe that, my lords.
Dismissed. Next.
My lords, just kindly given this observation, my lords, not prejudice the future of the future prospect, my lords, of the petitioner, my lords.
Obviously, it will not have it.
My lords, just kindly, just single line, my lords.
Next case.
Much of it. My lords, dismiss as infructuous, my lords.
Dismiss as infructuous, all right.
Much of it.
Very good. Counsel for the petitioner state that this petition has been rendered infructuous. Full stop. It is accordingly dismissed. Next.
Well, in this matter, but previous order were referred to mediation, but that has failed, my lords. The issue is, my lords, the High Court had granted divorce to the respondent on the ground of irretrievable breakdown of the marriage matters. But that power is not available to the High Court, my lords.
That's right.
That is my first point. Another point is, my lords, in maintenance petition, which is 5.1, my lords.
Now,
there is
decree under 142, then what happens?
There is a ground, there is no cruelty. First, they have filed the divorce petition.
Since how long they are living separately?
More than 18 years.
Well, 2005 marriage was there, and 6 I think malords.
Separately.
Yes.
Malords. What happened, malords? In maintenance petition, what happened?
Client is an engineer, he is a doctor.
No, malords. He is not engineer, malords.
She's a double graduate, my lords. I am a doctor. I am a doctor. I am a dentist.
In their petition, itself, they are saying that she is a housewife.
Okay.
Divorce petition, they are saying, and the petition filed by their parents against, they are saying occupation is a housewife. If they know that he is not working.
Wait.
Another point is, malords, there is more than.
The court did not grant any alimony.
Alimony was in maintenance petition, it is 18,000 per month.
Alimony was not granted.
No, malords. And malords, further malords, whatever.
Children out of the marriage?
No, no issues.
No issue.
No issue. But what I am submitting, malords, in maintenance petition, whatever maintenance is there, malords, they have also filed SLP, we also filed. Our SLP is pending, malords, their SLP has been dismissed. And they are, even thereafter, they are not making any payment. There is pendency of an execution petition against that, and which is more than 26 lakh.
What is the maintenance awarded?
18,000.
18,000.
But even that they are not.
Fight for enhancement of that.
Yes, madam. But their SLP has been dismissed, madam, and still they are not paying.
Answer the question, na? Why are you continuing on and on? So your SLP is pending for enhancement.
Madam.
It is not received today?
It is registered, ma'am.
5.1 is there.
Yes, ma'am.
And this is the petition against the grant of divorce.
Yes,
5.
yes, ma'am.
All right. Yes.
My lords, if I could only be given a minute, my lords. 18,000 is the amount that has been directed by the Honorable High Court, enhancing it from 6,000 as was ordered by the learned trial court. Now, my lords, 18,000 is from the filing of the petition. That would approximately amount to about 135 months. And my lords, as per my calculations, it will be somewhere around 25 lakhs or 24 lakhs 30,000. My lords, I have deposited about half of this amount before the learned trial court, about 12 odd lakhs. On the previous occasion, my lords had graciously referred the matter to the mediator. And my lords, in the order, my lords had specifically mentioned for a mediated settlement. My lords, and I very humbly submit, I have a favorable order, I have a decree for divorce in my favor. However, without prejudice and without raising any aspect, my learned friend said that it was granted on the ground of irretrievable breakdown. I very humbly denied that. There were also instances of cruelty. With or without that, my lords, I am completely covered by my lords' judgment in Shilpa versus Varun. My lords, more than 18 years we are living separately, no children out of the marriage. My lords, the marriage is dead for all purposes. I again very humbly state so. My lords, my limited concern, my limited prayer is to dissolve the marriage under 142. Insofar as the aspect of an alimony is concerned, it is 18,000 in perpetuity. So I am to pay 18,000 per month, my lords, till infinite period of time, if I may say so. My lords, regarding that, if the parties can arrive or by way of a direction of my lords, if there can be a permanent amount, because that is all that in my humble submission remains. Insofar as an aspect of cohabitation is concerned, my lords, my instructions, needless to say, are that I cannot. It was me who preferred my lords, a petition for divorce.
Not only he filed injunction petition, his parents filed injunction petition. They does not want her to come and then say he married dead because they are not allowing her to come.
That was already allowed by the Honorable.
Then saying that she is not coming to me.
I have that even in my favor. Vis-a-vis
the 9% allowed.
All right. Now, do you have an offer in mind?
My lords, I do. I have an offer, my lords. I have been informed by my clients.
What is that?
My lords, up until now, about 12 to 13 lakhs have been paid, my lords. I have spoken to my clients till about 2021. However, if, my lords, there is a figure that can come from my learned friend, I have no difficulty convincing my clients vis-a-vis that. My lords, in their grounds, they have asked for an enhancement to the extent of 45,000. That is there. My lords, if a calculation is to be done with respect to this, right from the time of them filing a petition, it would be about 60 odd lakhs right now, my lords.
And what is the age of the parties here?
My lords, I'm 58. I'm 58.
And
58,
she will also be 55.
She should be like
around.
my lords.
Of assets and income or something like that?
My lords, no. My ITRs were filed. That has been noted by the Honorable High Court as well. My income was stated. Now, my lords, my learned friend says that these are self-serving documents and the fact that you deliberately are showcasing lesser income than what you have. However, what is on record is on record, my lords. I preferred my ITRs. Vis-a-vis ITRs, they are not before my lords. I haven't been able to prefer a reply to the criminal SLP, my lords. Against the civil SLP, I preferred my reply. Subsequent to that, it was referred to the mediator. If my lords are hearing it on merits, finally,
Have you remarried?
Please, my lords.
Have you remarried?
No, my lords. I haven't. I could have only after this order, my lords, granting me divorce, but I haven't. My humble submission, my lords, it would be misery even upon my lords, the respondent's client. I have nothing further to say to this because the marriage is dead, my lords, for all purpose. Okay. $50, my lords.
50, which will take care of the areas and everything.
Lords, could I be given some time to confer with my clients regarding this? If it could be after a week or 2 weeks, and if I can convince my clients regarding
that. On phone right away. How do you want to keep pending?
My lords, I may not be in a position to answer right away because my humble submission, my lords.
Surgery.
My lords, it is more than the reach that he can offer right now. Only after a week, my lords, I not seek a time.
If we either reverse the decree or we enhance the maintenance, both will be more costly to him.
No, I fairly say.
So then always
an aspect that I have already informed. Could it kindly be next week, my lords? It will give me better time to convince my clients. That's all that I'm saying. My lords, I'm not negotiating with my lords on this.
Having heard in terms of the parties, a figure of 50 lakhs as permanent alimony has been indicated. counsel for the respondent husband. There's also the counsel for petitioner wife. May obtain instructions. List again, next Tuesday.
Where? I'm sorry.
My lord, so today I will take first step, my lord.
Today you take rest.
No, first step, my lord. Because the last week we were some busy with some other work. By mistake we did take.
Service need.
Item 6.
Yes, 6.
Rest of the time that we get.
Thank you. What please, my
My lord, I beg to appear on the petitioner, my lord. She's a lady, my lord. We have filed our assets, my lord. Affidavit of assets had been filed, my lord. Parties are here, my lord.
Filed my assets also, my
Yes, both parties are filed.
Both parties are here, my lord.
My lord, both parties are here, my lord, but my lord, can I read the affidavit, my lord, filed by me, my lord, because I am an advocate. I am getting, my lord, I'm with a senior, my lord. He's paying her, my lord, 4,000 rupees, my lord.
You are the husband?
Yeah, I am for the wife.
For the husband,
I am for the wife, he is for the husband, my lord.
You are an advocate?
Yes, my lord. She's an advocate.
No,
My lord,
you are also an advocate?
He's at +2 pass, my lord. He's working in marketing, my lord. He was diagnosed with tuberculosis, my lord, so couldn't work for last 1.5 years, my lord. Now he started working again, my lord. Filed my affidavit, my lord.
My lord, he has filed an affidavit that he is the marketing managing in a company which is owned by the mother, my lord. He's owned by the mother, my lord. And he is getting a salary of 35,000, my lord. There's an arrears of 13 lakhs, my lord. Originally, my lord, in maintenance, my lord, 6,000 was granted, my lord. Then, my lord, final
Now,
order.
the trial court and the high court both have.
It's a reversal, my lord.
Oh, yes, my lord. My lord, this is the matter, my lord, where the, my lord, if on merits, my lord.
Yes, sir.
Trial court dismissed my petition, my lord. High court,
my lord, allowed, my lord. On the ground, my lord, there are some cases, criminal cases filed, my lord. That's a cruelty, my lord. It's ipso facto, my lord. That's the ground for, my lord, divorce under Special Marriage Act, my lord. Lord, there are judgments, my lord, to show, my lord, no. If a criminal case is being filed with a lady, my lord, husband can't come tomorrow to the court and tell that, my lord, he has filed a false criminal case against me. That's why ground for the divorce, my lord. I have 2 judgments, my lord, to show that on merits, my lord. But, my lord, be as it may be, my lord. He says, my lord, I am.
According to you, there are chances of joining together?
No, my lord.
No, my lord. No. He is married. He is married, my lord, subsequently during pendency of the stay granted by this honorable court. But there is a contempt petition also, my lord. My lord, he has a son also, my lord, which we don't know when he was born, my lord. But ultimately, my lord, I demonstrated before this honorable court, my lord, during pendency of the stay, my lord, this is a gross contempt by, my lord, committed by this person, my lord. But my lord, now he has come with the facts, my lord, gross, my lord. There's a
out of the marriage there are no children.
No, my lord, first man, not with.
They're staying separately since 2015, man.
My lord, that's my lord. He says, my lord, I am working in a company, my lord, which is in Ludhiana, my lord, and that is called Trasmenos. He's a sales executive in that, marketing manager, and he's getting salary of 35,000. My lord, see, my lord, the latest, my lord, we got in Google, my lord, and it says, my lord, he is a CEO of company, my lord. There is Sony, my lord. He is the CEO of the company, my lord. That company is being owned. There are 2 companies, my lord. Telecom? Sells mode. She has 2 companies, my lord. The family owns 2 companies, my lord. I have filed it earlier also. One is Trasmos. It's the company owned by the family. Mother is but here, my lord, he says in an affidavit, my lord, and says, my lord, that I am the marketing manager, my lord. I am getting 35,000. My lord, we could get, my lord, on Google, my lord. He is the company CEO, my lord. There is Sony, my lord. And my lord, another company, my lord,
What is the salary?
My lord, he says 35,000, my lord. High court. My lord, he says 35,000 per month. I am getting from the company, my lord, which is owned by his mother and other partners, my lord.
CEO don't get 35,000.
I don't know, my lord. He has to make his, my lord. He has to make his, my lord, submissions clear, my lord, and my lord, receive, please.
All right, keep it.
I got it today, my lord, my client.
Now you want to settle it finally?
I want to settle it.
How much do you want to? What is your offer?
My lords, in fact, my lords, all the interim maintenance, my lords, is up to date, my lords. On February,
how much is the maintenance you are paying?
6,000 rupees I had been paying, my lords.
They are also, my lord, areas, my lord. And now, my lord, 25.
He says it's up to date.
No, my lord. I filed an affidavit, my lord. In areas, my lord.
Let me complete, my lords.
Yes, complete.
My lords,
don't make a wrong statement.
February, my lords, the final maintenance has been awarded of 25,000, my lords, which I have challenged in High Court, my lords. Notice has been issued in that one.
That is pending.
That is pending, my lord.
That areas comes
After
from
that,
30 lakhs, my lord.
after that,
I'm sorry.
After that, there will be areas, man. I have not paid according to 25,000. I have paid according to 6,000. That was the interim maintenance, man. Because I have asked the respondent hearing, man. He's because of his financial health presently, man. He was saying 10 lakh rupees, man. So I said that cannot be a reasonable amount for me to also take to the court, man. He said that I can pay 15 lakh rupees, man. Ask them, man. Then, man, I can convince him, man. That's why I asked him.
In trial court, they weighed 25,000, 25 lakhs, excluding 13, if it was 13, I had asked my client, I'm not a client, she's not a client, she's an advocate, it's pro bono.
Yes.
It's completely pro bono. He says 50, because 50 including 13 areas as rent, as maintenance charges.
30 or 13?
30, please.
13 areas.
13 areas. And the turnover in that company is 14 lakhs to 1.5 crores per annum. That's the trust cost where he's the CEO, and he says I'm the marketing manager. There are two companies, there are two houses, they have cars, they develop.
He's not in a position to pay 35 dollars. I have placed on records his medical record.
Beg, borrow, steal, do something and get the project.
35 he will not be able to pay, my lord.
So let them continue to pay maintenance at rate of 25,000 for lifelong.
Yes.
And then she'll seek enhancement also. That will be
She
much
says
more
40,
expensive.
She says 40.
All right, we will decide ultimately.
I'll leave to Lords. You will work as an advocate.
Yes.
I told him you will work as an advocate.
Yes.
In line.
My lord is saying that at maximum he can do 20, my lords. That is also by backboring steel, my lord.
20 plus areas, it will come to 35. That's how we had also calculated.
My lords, 20 in total, my lord.
No, not 20 in total.
My lord, then my lord may.
All right.
Because my lord, he's here, my lord. Let him make a statement. I cannot make a statement on his behalf, my lord. He has to pay, my lord.
No, the statement, we direct him, he has to pay, it's finished.
My lord, may permit me one thing, my lord.
Don't want his consent, we will only protect that figure to him.
May consider, my lord, decreasing it, my lord, because he's actually, my lord, not in a position. My lord, the family is married or remarried also, my lord. You have to take care of that family also.
Yes.
I told my lord that this
all that you must consider.
That goes against me only, my lord. My lord may consider doing 25, my lord. No. Now he will be able to pay, my lord, that amount. 35 will not be able to pay even by backboring steel, my lord.
We will grant you some reasonable time also.
My lord may consider doing it 30, my lord. But he'll actually not be able to do it.
Parties. In the interest of both the parties, we deemed it appropriate to fix a lump sum amount as permanent alimony and close all.
My lord, they sought 25 lakhs before the learned trial court. I was not in a position to pay that also at that time.
Counsel, when I'm dictating, I don't like
I apologize, my lord. My lord, because he is the...
Whether senior or junior or anybody.
I go down, my lord.
Just wait, when I complete my dictation, you can again start your argument.
I would not want to do that.
Permanent alimony of rupees 35 lakhs, which will take care, which will include the areas also, outstanding areas of maintenance, with respect to which an appeal is pending before the High Court. Said amount to be paid in two parts. An amount of rupees 20 lakhs to be paid on or before 30th June 2025, and the balance 15 lakhs to be paid December 2025.
Once we make submission, my lord, I'll end it there.
1 minute, this is all complete.
Please, my lord, I thought it was complete.
2025. Full stop. Subject to payment of the said amount, the petitions have been disposed of, and the decree of divorce granted by the High Court shall stand confirmed.
Well, we have criminal cases also, my lord. I filed all the cases to be withdrawn.
Pending criminal cases between the parties shall also stand quashed. Details of the same, you provide the details of all the criminal cases against you.
I have, my lord, I have.
I'll do that.
I'll have.
But there's
The
I have.
details of which are given here under.
We'll give it.
The registry shall draw the decree and inform the concerned court of this order so that formal orders for whether may be passed. All pending dispute between the parties shall stand.
Including appeal, my lord. We don't have appeal number.
The appeal, including the appeal before the
High Court, my lord.
against the maintenance order.
Yes, my lord.
and they have also filed against DV and Malad.
Yes, everything was
I
done.
said.
Complete details of all the cases.
Yes, my lord. I'll give it.
Now to submission number one.
Firstly, Malad may consider reducing it. Malad, he's
Number two.
Two Malad, if Malad are not agreeing to me on reduction, Malad, first payment I'll make by September, Malad. Second payment by March, Malad. In fact, Malad is not in the financial condition to make payment by June, Malad. Till September, Malad, 20 lakh rupees, Malad. Till
All
March.
right, we will
Make it three.
increase the installments and time also. Wait. So 30th June तक 10 lakhs कर दीजिए.
Yes.
Please, Malad. That
Another 10 lakhs by 30th October, 31st October, and the balance 15 lakhs by 31st March 2026.
I'm good. I agree.
Okay, next.
I'm grateful.
Malad,
That is.
still asking me,
We'll
but
get
that's all I'll make again, Malad.
No, next case.
Malad, if possible, Malad.
Next case.
The matter was sent for mediation. It has failed.
Item 8, 7 हो गया. Huh?
7th, 8th.
ये 7 है. The 6th.
Contempt में 7. 7.1. Just paper देंगे.
Item 6 में क्या हुआ? Seven year है. नीतू alias निकिता.
Contempt में close.
Contempt close कर दो.
But by the impugned order,
yes,
the Honorable High Court has set aside the decree of divorce granted by the family court. This matter was sent to for mediation, Lord, and mediation has failed, and thereafter the matter is before Lord Simpson. Lord, the admitted position in this case is that for past 17 years, they are not living together. And Lord, there is no, at present, Lord, there is no child out of the wedlock. And Lord, for all practical purposes, this marriage is dead, Lord, and there is no chance of.
What?
Lord,
Do you move for a living?
Lord,
What is your profession?
They are poor farmers, Lord. Poor farmer. Farmer. He has no other occupation, Lord. Of divorce was granted by the family court subject to payment of rupees 15 lakhs. But
have you put that amount? No.
No, that was challenged before the Honorable.
That was challenged by her.
Yes, Lord.
Not by you.
No, not by us. Certainly not by me. But
what is the date of the family court judgment?
That date I've given. It is
June, July.
Judgment is of 7th July 2021.
About 4 years back.
Yes, Your Lordship.
Yes. What do you say?
My lord, my instructions are that she wants to stay with the husband, my lord. As far as the money is concerned, she doesn't want any element.
She doesn't want any.
No, my lord. She wants to stay. The matter was referred for mediation, but mediation, her only point is that she wants to stay with the husband. I leave it to my lords, whatever.
It seems not continue.
My lord, we have tried our best. But
even in mediation, it does fail.
I completely leave it to my lord.
So you want a permanent alimony? You can increase that amount of 15 to.
My lord, I leave it to my lords on this because she doesn't want any alimony, my lord.
We will fix it if she wants to accept it. She may accept. She may not accept it.
Whatever, I leave it.
Okay. So is that it? 5 lakhs.
Lord, he's a farmer. He will have to sell land.
Whatever you have to.
Beyond that, he has no other means.
She will not take it. You will get back your money.
Lord, I don't want that. She should not take it. And it should be fair, not fair on my part, Lord, at least. So it should be 20, my lord. I will convince my client.
My
that
lord,
it should be-
my lord, in the mediation, he has already offered more than 25 lakhs.
More than 25 lakhs?
Somewhat around 50.
He was there in mediation. Lord,
Yes,
I-
what
it was there. It is not
That was the
like
offer, but my lord, she doesn't want it. The money.
She doesn't want
it. No, man. We leave it to my lords on this.
Okay. Third come for the parties. Exercising power in 1142, we allow the disposal of this matter. The side involvement in the marriage between the parties. And fixing permanent alimony of rupees 20 lakhs if we paid within 2 months by the appellant to the respondent. ठीक है? File भेज दीजिएगा मेरे पास.
Very good. Obliged.
He's reached a settlement. Settlement agreement has been drawn. The only
Where's the other side?
they have not entered appearance. Although I have the document in Hindi, my lord, it says that they have to take steps to approach this court because we have to file joint application.
You could have engaged one of your friends from the other side. That's how you always work.
I gave that suggestion. My lords, perhaps, my lords, I can give a
You
suggestion.
should be actually getting instructions from both sides.
I had.
Why would she be engaging a counsel?
I had a word. I had instructed him to do that. My lords, may I say a request for something? Let my in the settlement agreement, there is a clause that they would approach the civil court, family court, for the purpose of dissolution of marriage. The lordships could record that it can be dissolved right here. Everything can be done here.
But
That
the
will
sex not here,
I will take fresh steps. It will incentivize them to come. I'll bear the
We
expenses.
are fixed. This is the matter next week.
Please.
You make alternate arrangements.
I have been.
Appropriate arrangements, not alternate.
A word from my lords in the order, my lord, would help me in getting them here.
Okay, why Mr. Padmesh Mishra, Learned Counsel for the petitioner, states that parties have already arrived at a settlement. However, due to some difficulty, the respondent has still not put in appearance. As prayed, a week's time is granted to make appropriate arrangements. This after Monday. You understand the appropriate arrangement? What else? Next case.
I'll file the.
It's on next Tuesday.
Grateful.
Then I am seeking a short passover.
Item 10. You want a passover?
Lodge.
At least may have it any other day.
Any other day, yes. Next week.
Lodge.
Very good.
On the request of counsel for petition, this next week. Next.
Public.
My lord, learned amicus is in another court. Can you pray for passover?
Yes,
Ms. Makija,
He's on our legs in court.
what is this matter about?
Your Lordship, this is the matter about of the he has filed the appeals of the delay of 4,000 days.
The legal service authority.
Please, Your Lordship.
tell you about the e-prison software?
E-prison software, Your Lordship.
What we could see from whatever has transpired so far, that software, if applied properly, if used properly, can take care of all these issues.
That's right. That's right. Your Lordship, that is being monitored in.
We don't know how far the execution is.
That's right. That's right. But it should take care of it.
In some other matter.
Please. In Sonadhar.
Your
In Sonadhar.
Which court?
Court number 5, Your Lordship.
Court number 5?
Four. Sorry, four. I apologize.
Your
Four.
Lordship, that judgment has passed.
It is being monitored. It's being Court number 4. But this issue is slightly different in that sense. Your Lordship recalls in Suhas Chakma, in fact, Your Lordships had passed those directions where an assessment was made of all convicts who hadn't in fact filed appeals, and reasons were sought from each of them. Those reasons were filed by NALSA, and we had placed those reasons. There is a judgment also after that. So there were several reasons because of which convicts had not filed those appeals. It was not necessarily accessed.
Please. It's not that software which we are talking about is not limited to filing of appeals. It takes care of parole applications.
That's right.
Everything.
Everything.
It's a very
Everything.
exhaustive
That's
software
right. That's right.
Which we developed in Rajasthan.
That's right.
The Supreme Court Legal E-Committee has also done something in that regard.
There was a demonstration also. We were part of that demonstration.
Precisely. So if that software is applied in the entire country religiously, probably these problems will be sorted out. What more is required thereafter?
No, once that is fully functioning, then nothing more is necessary. But the problem is that different states are at different stages of this.
Data and update migration of the data in real time.
That's
the whole issue.
That's the only issue. That's right.
So we need
that will take care of parole. That is being monitored.
Number 4,
please.
Your Lordship, seeking indulgence, Your Lordship has appointed the committee in Supreme Court. Your Lordship, after that, Ms. Makhija has filed the report for Your Lordship. In that, Your Lordship, Ms. Makhija is seeking some direction from this court for Your Lordship.
Where is she?
She's on her legs, Your Lordship. She's in court 3.
Club this matter with that matter. If there.
Suhas Chakma still continue?
Your Lordship, judgment has passed. Your Lordship.
Open jail is continuing. This aspect is over, Your Lordship. It's been disposed of by a judgment. I'm carrying that judgment. That, in my respectful submission, takes care of these issues. See paragraph 32, page 31.
Yes.
Your Lordships have page 31. It says reasons given by convicts for not filing appeals. That's right. So this assessment was made. May I read that? Paragraph 32. NALSA in its report of 6/9/2024 has opined that the convicts who have not preferred an appeal had adduced the following reasons. 1. Convicts were not interested in preferring an appeal as they were satisfied with the current judgment and the order on sentence. 2. Convicts had served a substantial part of their sentence. 3. Convicts' appeal was rejected by the High Court and hence they did not want to file an appeal before the Supreme Court. 4. Convicts lacked the financial resources to prefer an appeal. 5. Convicts wanted to consult their families before deciding whether or not to prefer an appeal. 6. Convicts wanted to engage a private counsel. 7. Convicts had a fear of enhancement of sentence in the appellate proceedings. 8. Convicts had originally pleaded guilty to the offence and were hence not inclined to prefer an appeal. 9. Convicts had multiple cases pending against them. 10. Convicts were not willing to state any specific reason for not preferring an appeal. 11. Convicts had recently been convicted. Therefore, with respect to 1, 10 and 11, they were asked again. Because that is with respect to
NALSA or legal service authority apprising the convicts
regarding
the right to file appeal and
assisting in filing all the way up to this.
What we are trying to say is that this data, you want physical presence in jails and then you take the prisoner's opinion. Rather than that, we feel that if there is a comprehensive migration of data of every prisoner, it should not be required.
It's underway. It is underway.
The pop-up will be there.
The pop-up will come. In fact, emails are sent in some states. For example, in Delhi, emails are sent to the prison superintendent
Right.
saying that they are eligible.
So basically, the issue which is taken up in this matter is covered by this.
Your Lordship will wait for the learned amicus. I'm not
Your
certain
Lordship,
if he
kindly
wants to
see
say something.
here page number 1200. Your Lordship is a learned amicus seeking some direction from this court, Your Lordship.
Sonadar.
Can you bring the orders passed in Sonadar?
I'll do that. At 2 p.m. I'll bring all the orders because there are lots of orders in that.
Next Tuesday.
I'll do that. I can file that, Your Lordship, because it's a big compilation of orders. I can. I'll do that.
Ms. Makhija is occupied. List again next Tuesday.
Obliged, Your Lordship.
Obliged.
So file for it.
Wait, please, my lords.
Yes.
My lords, it's an appeal by a landlord, my lords. 31 years he is fighting litigation, my lords. I won from appellate court, my lords, first appellate court, finding of fact recorded in my favor that they are trespassers and therefore not entitled for the protection of statute, my lords. They cannot be termed as licensee, my lords. High Court, my lords, on first.
Now, you filed the suit, regular suit for eviction or?
I filed suit for eviction, regular suit, my lords.
Regular suit for eviction.
My lords, I'll just brief the facts, my lords.
Yes.
I rented out property to one Madhuben, my lords.
Madhuben.
Madhuben filed suit against these present respondents in 1988 saying he is my brother. He came to my house for 4 months period because he was dispossessed from his house. Thereafter, he refused to left. I went to Hyderabad. Now I have returned and he is not letting me in.
Okay.
So, suit for injunction.
Collusive suit.
Millards, yes. She files a suit for injunction, Millards. Thereafter, he files a counterclaim in that, Millards. And then they enter into written consent.
You are not a party to that.
I was made a party.
You are
Then I came to know that this thing has happened because I was receiving rent from Madhuben. Then, my lords, written terms are agreed in which they agree.
Now your tenancy with Madhuben is in writing or oral?
That was also oral, but admitted, my lords. Admitted, no dispute. Since 1950s, my lords. And my lords, then upon coming to know, I issue a notice. I file a suit for eviction against them, my lords. Madhuben is also made a part.
Madhuben doesn't appear and contest.
She never appears because she has, my lords, taken whatever consideration, whatever, my lords. And in the written consent itself is recorded that she will facilitate transfer of tenancy in their name. Now, my lords, trial court dismisses it on the ground of that section 12A that demand notice has not been made in accordance with law, etc. My lords. First appellate court records a specific finding. They have failed to prove how they entered into possession with my consent because ultimately they have to be licensee, my lords, to this thing get a protection. Even subletting, that's okay. The contention was they trespassed, my lords. Trial court, first appellate court allows my suit. They filed civil revision. That is allowed. I come before my lords. My lords set aside that order, remand it back for fresh decision. Now it has again been decided. And that's why, my lords, I'm here. My lords.
Now what does the High Court say?
High Court says 15A protection is available to them. They are licensee. And that is, my lords, something, my lords, which needs consideration of my lords, on two aspects, my lords. And since 89, they are not even paying anything.
You refuse to accept from them.
That's right.
My lords,
That's what the finding of the court says.
Of a trial court, my lords. Because I was, my lords, persecuting them as a trespasser, my lords. But they are legal. Trespasser. And if they are trespasser, they are not entitled for protection.
Yes.
And that's my case, my lords.
The issue is something slightly different. He files a suit, my lords, for eviction on the basis of multiple grounds under the Rent Act. The trial court dismisses the suit. The first appellate court finds in his favor on two grounds. One is on the ground of non-payment of rent, that is under section 12 of the Rent Act. And second is under 13(1)(e) of the Rent Act, which is unlawful subletting. On these two grounds, my lords, the first appellate court finds in his favor.
How
Yes, I just indicate. Please have.
What is the right of
so,
your
so therefore,
profession?
let's please have section 5 and section 15 of the Bombay Rent Act.
On facts, please. How
Yes.
you come into
I come into the
claimant?
picture admittedly around 1965.
Around, forget about around. In what capacity?
Well, which is why
you don't dispute that Madhuban was the actual tenant.
Madhuban was the actual tenant.
How do
I
you
come
get
into
it?
possession, and which is why, my lords, I am stating that section 15 protects anyone in possession irrespective of whether he is a lawful tenant or not. Please, which is why the matter was once remanded back. Please, therefore, my lords, have the finding of the court, first of the straight away of the High Court. Please have page 7. And
what is the extent of the property?
500 square feet.
500 square
Fit inside, my lord.
Inside.
It's a flat. It's
inside.
Inside.
Bombay.
Yes, my lords.
It's an apartment.
It's an
It's an apartment.
500 square feet apartment.
That's right.
And what is the rent you are paying?
123 rupees.
123 rupees.
That's right. It is. But Manoj, on the legal issue, Manoj, please have the finding and kindly see a judgment of your lordship which says that lawful or unlawful possession is irrelevant if he's in possession prior to 1973. Which is why your lordships had once remanded the matter back. The High Court had once decided against me. The matter was then remanded back. Please, for a moment, Manoj, have page 7. Page 8, I'm saying. About para 13, about 4th of fifth line after 1965, my lords, has
Page 8.
Page 8, para 13, about 5th or 6th line from the top, my lords, after 1965.
Yes.
After 1965, she along with her husband has abandoned the suit premises. This is referring to the original tenant. Madhuban. Subsequently, in that suit on 10th October 2001, consent terms were arrived at between defendant number 1 and defendant number 2A to C. I am defendant number 2A. As far as B to C is concerned, my lords, it has been dismissed for non-prosecution. That is my second submission I'll make to your lordships as far as 2B and C are concerned. And other family consent terms were arrived at between defendant number 1 and defendant number 2A to 2C and other family members where the plaintiff therein accepted the findings recorded in the order dated 27th October 1993. The plaintiff therein declared and confirmed that she along with the family members left Mumbai in the year 1965. Defendant number 2, my father. Defendant number 2 was completely in control of the suit premises. It is no doubt true that the plaintiff herein was not made a party in that proceedings. Findings recorded at interlocutory stage as also consent terms will not be binding on the plaintiff, even if I exclude from consideration the proceedings of the City Civil Court. Nonetheless, evidence on record in the present case clearly shows that defendant number 1 had permanently shifted to Hyderabad in the year 1965 and defendant number 2 was in occupation of the suit premises from 1965 onwards. Defendant number 2 was in exclusive possession and control of the suit premises from 65 onwards. Defendant number 1 was not having control over the suit premises after she along with her family members shifted to Hyderabad permanently. Thus, one has to conclude that the defendant number 1 has parted with possession of the suit premises and created interest in favor of defendant number 2 in 65. Now, please see section 5 and 15, my lords, because that is what has been interpreted by your lordships also in another judgment. In this act, unless there is anything repugnant to the context, 511, tenant means any person by whom or on whose account rent is payable for any premises and includes A, such subtenants and other persons as have derived title under the tenant before 1st day of February 1973. Now please see 15 subclause 2, which is at the end of the page. Please have that. The prohibition against subletting. This is with regard to the ground of unlawful subletting. Prohibition against subletting of the whole or any part of the premises which have been let to any tenant and against the assignment or transfer in any other manner of the interest of the tenant therein contained in subsection 1 shall, subject to the provisions of this subsection, be deemed to and have had no effect before the 1st day of February 1973 in any area in which the act was in operation before such commencement, and accordingly, notwithstanding anything in the contrary contained or in the judgment or decree of a court, any such sublease, assignment or transfer of any such purported sublease, assignment or transfer in favor of any person who has entered into possession despite the prohibition in subsection 1 and purported sublease, assignee or transferee and has continued in possession on the date aforesaid, that is 1973, shall be deemed to be valid and effectual. Now, this clause, my lords, came up for interpretation before your lordships in a judgment, which is, my lords, I just pass on a copy, 2011 5 SCC 128. And please have para 27 of this judgment. My lord says, para 27 at page 138. Page 138. But then, may I just read that? But then came section 15(2) that removed the unlawful tag from any subletting, assignment, transfer, or interest in any other manner or licensing, though contrary to subsection 1, that were made before the 1st day of February 1973. The second part of section 15(2) laid down that regardless of the prohibition in subsection 1 and notwithstanding anything contained in any contract or in the judgment, decree, or order of a court, a sublease, assignment, or transfer of interest in any other manner shall be deemed to be valid if the person in whose favor transfer is made entered into possession of the dismissed property and continued to be in possession on 1/2/1973. Therefore, my first submission is, my lords, if it is accepted that I came into possession around 1965, prior to 1973, then 15(2) will protect me from the contention that I was an unlawful sublessee, because the Act, insofar as 15(2) is concerned, will not apply at all. The finding of fact is that I have come into possession prior to 1973, and that, my lords, is shown by about 4 documents. Please have page 7, para 12 of the High Court statement. My possession as far as in 1965. Please have page 7, para 12.
The current rent of such a property?
My lords, it should be more than 30,000. I can't say with my lords.
1 lakh rupees? 1 lakh?
Please, my lords.
1 lakh per month?
No, that's not 1.
I don't know, my lords.
30,000 you will get Delhi.
It's signed, my
Why
lords.
signed?
Please, my lords. It would be more, my lords, but I can't, my lords, say without.
Take instruction.
I'll do that, my lords. I'll do that, my lords.
If Mr. Madhyal wants to continue,
Yeah, he should pay the rent.
he
That's
should pay
it.
the rent
Yes, my
from
lords.
the date of filing of the suit. When did you file the suit?
1991, my lords.
Yes.
Grateful, my lords.
You've been enjoying the premises owned by the appellant.
No, my lords, there is a issue.
Last-
Because at the end of the day, my lords, if the finding
He
is
has
that I
to
have,
do justice between the
no,
parties.
that's right, my lords. I
You
quite see
cannot
that the
be
rent,
landlord in love and getting 123 rupees
I
as against
see
the property
123,
which
my
must
lords,
fetch him
is
50,000,
certainly very
60,000,
inequitable.
80,000,
123 is
whatever.
certainly inequitable.
He passed
But-
away, my lords, fighting this litigation.
Ah,
That's the plight, my lords.
everywhere it's the same.
Yes, my lords.
All right.
You also take instruction.
We'll also
once
take
there.
instruction.
Otherwise you get.
We'll also take instruction. I'll take instruction.
And tomorrow?
Friday? Next week, your lords.
Next week. We can list again on next Tuesday, that is 29th April 2025, to be taken up immediately after fresh matters. Fresh and bail matter. Huh?
Yes.
In the meantime, counsel for the parties may obtain instructions with regard to the current rent of the premises in question.
Grateful, my lords.
We'll find.
Current market rent of the premises in
123, I also see, my lords, is absolutely inequitable.
There are bungalows and bungalows with 1 rupee,
No, I quite see that, my lords, is rent
101
tag.
rupee, 51 rupees.
That I quite see.
Then what happened?
Grateful.
Not listening. Please, ask for me.
Please, my lords. One is kindly seeking a week's accommodation at number 17, my lords. The council is not.
Any objection?
No. My lord, may I
Request
just
of
make,
counsel for petitioner list after 1 week.
my lord, may I just make a request, my lord? My lords may call for the records in the matter, my lord, if my lords are kind.
What is this matter about?
It's a specific performance suit, my
Why
lord.
do you want the records?
No, but because they rely on certain documents, etc. Those documents are not on record.
File the documents.
We are
They have not
trying to
made
try.
it.
Yeah, they have.
We had filed.
Why are you worried?
Okay, yes.
Is their appeal,
Yes.
their petition,
Yes.
specific performance?
Yes, my lords.
You are
They have to pay.
plaintiff or defendant?
Yes.
I was the defendant in the.
Defendant.
I was the
Okay.
defendant, my lords.
You lost, decree has been there.
Yes,
If purchases in possession, the sale consideration was 1,75,000. 150 you received.
Yes. So continue
So
more well.
which is how much you make out of the remaining 25,000.
All right, next week.
Next
How
week,
will the instructions on
completely.
that?
Yes, ma'am. Grateful, ma'am.
You also completed with instructions.
Yes, ma'am. Yes.
That you want to retain the property or you want to leave it?
No. I'm in possession, my lord.
Yes.
Possession can be taken away also. Next.
Grateful, ma'am. Grateful.
For respondent number 4 in this matter, we are seeking some time to file an affidavit in terms of the last order.
How much time?
2 weeks, my lord.
Counsel for the respondent place was granted 2 weeks further time to file the affidavit in terms of the previous order.
Much.
Most grateful, ma'am.
Next.
Lord, I beg to appear for the petitioner.
My lords, a short passover.
My lord, here.
My lords, I request
to
a
serve-
passover, my lords. The arguing counsel is held up in another court.
All right. What do you want?
My lord, nothing. There is an exigency, my lord.
Huh?
My lord, many a times, my lord, it does not come back again.
They will come back again. That's right. What is there is no urgency?
Yes, my lord.
What is the urgency?
My lord, what has happened is, my lord, out of one single incident, 2 FIRs, one in the state of Tamil Nadu, one in the state of Karnataka has been filed. Now what has happened is, my lord, charge sheet has been filed. Now, charge has been framed in as regards one charge sheet in Tamil Nadu. And it is...
Very good.
Yes.
You can start.
My lord, I may be permitted to circulate a small compendium of cases.
So many cases you need to rely upon. One should be not good enough.
Yes, my lord.
So where do you want the trial to take place?
My lord, charge is already framed in Tamil Nadu. My lord, the incident happened in Tamil Nadu. My lord, if I may take my lordship to the...
It's a video which has been circulated based whereupon the FIRs have been filed.
My lord, what had happened is an alleged inflammatory speech at the instance of the accused happened in Madurai at Tamil Nadu.
That's why that was circulated and based upon the FIR has been filed.
Yes, my lord. Yes, my lord.
Tamil Nadu, Madurai, because these are-
All the witnesses are from Tamil Nadu. Yes. And charge is framed in Tamil Nadu.
Leave granted allowed.
Obliged. Lord, will I be permitted to circulate a short note on the relevant paragraph of the judgments?
Do that.
All right.
Obliged.
Parties may file small, brief notes.
Obliged.
Within 3 days?
Yes, my lord. Yes.
Within 3 days.
We have certain millards in the mediation. And as per the millards.
Matrimonial dispute?
Yes, millards. Millards has sent to mediate settle millards. 36 lakhs, 50,000 millards I have to pay to them millards. There are 2 tranches millards. One is millards, 26 lakhs 50,000 by 15th of May millards. Out of that I have already sent to her 7 lakhs millards. And the next tranche millards I have to pay 10 lakhs by 15th of June millards. And millards divorce millards we have agreed for since they are residing millards separately since April 2010 millards. So we have agreed that millards may pass. Already file millards 142 application also. So if millards may guarantee millards.
And if you don't pay, then what happens?
Millards then millards can be revived millards.
Are you agreed for mutual divorce in terms of the
Your lordships were agreeable for mutual divorce, but subsequent to payment.
Yes, the decree will be drawn subsequent to payment.
Yes.
But we will
Yes, your lordships. We are
resolve the
agreeable to
marriage.
divorce, your lordships.
The decree will become effective only after
Yes,
payment is made.
And millards there are so many cases pending. All can be millards. Number 3 mentioned.
It is all mentioned in the
application 42. Yes, ma'am. In the millards mediation settlement.
Okay, please give by 142 application allowed. Marriage is on. The decree will be drawn only after the entire payment as agreed is paid and proof of deposit is filed before the court, before the registrar.
It's deemed to be closed.
And all pending cases need to be closed. Registry will forward the copy of this order to the concerned courts only after decree is drawn.
Deeply obliged. Deeply obliged.
Obliged, your lordships.
Item 21.
My lord, chiefs had asked for a report from AIMS. We'd filed that report by way of an affidavit.
Yes.
Yes, my lord. We have received the report, my lord.
Yes.
Unfortunately, AIMS could not come to the conclusion what is the cause of death and
Obviously,
what. My lord.
So nothing is available in physical form before the aims. Whatever material was provided, aims could have done its best. Yes.
My lord, I have taken out a IA. IA number 63866, my lord.
Yes.
My lord, this is in view of the report filed by AIMS, my lord.
Yes.
Your lordship, may kindly turn to page number 2 of my IA.
Yes.
At para 2, my lord. Sorry, para 3, my lord. The petitioner submits that on 3/2/2025, respondent number 9 filed its counter in the present SLB, annexing therein certain correspondence with respondent number 10 and respondent number 1, 2, and 3. My lord, respondent number 9 is the medical DMHO, that is Andhra Pradesh, and respondent number 10 is the AIMS, my lord. The petitioner submits the respondent number 10 filed its counter on 5/3/2025 in terms of the additional affidavit, annexing therein final opinion of the respondent number 10 on the correspondence of the respondent number 9 and certain treatment details to the deceased. The petitioner submits that after going through the counter and the documents therein filed by the respondent number 9 and 10, it prima facie appears that the respondent number 10 could not form its opinion as the required material, articles, videos, photographs, and visceral samples of the deceased was not supplied to the respondent number 10 by the respondent number 9, which is reflecting at page number 11 of the counter filed by the respondent number 10, my lord. The petitioner submits that the unanimous opinion of the medical board formed by the respondent number 10, which is reflecting at page number 11 at para 2 of the counter as follows. The medical board has only perused the documents submitted in the said matter without any interaction with the doctors who have treated the patient or the relatives of the disease. The medical board also does not have any knowledge about the medical facilities, qualifications of the treating doctors, and the infrastructure of the hospital where the disease was treated. Hence, opinion could not be drawn. My lord, here I will just explain, my lord. In the first line, my lord, the medical board has only perused. Only, I am emphasizing what the word only. Why? Because the viscera report has not been sent to them. Because the viscera was not sent to them. And on the first occasion only, my lord.
Mr. Counsel, the viscera was consumed in the examination way back when the incident took place. It wouldn't have been retained for so long. When he directed the examination, the board's, the IO sought opinion from the board. When did the incident take place?
My lord, the incident took place on 14th of July 2023, my lord.
You presume that the viscera would be still available?
My lords, I
No, my lord.
state, can I answer this?
May I complete, my lord?
Yes, yes.
My lord, incident took place on 14th of July 2023. My daughter was declared dead on 16th of July. 17th, that postmortem was conducted. And thereafter, the sample was sent for postmortem forensic examination, my lord.
Yes,
Now, my lord, as per the reply filed by the respondent number 3, who is the concerned SHO, says that in view of their indent order, indent request, they have not requested the RFSL Andhra Pradesh to preserve the viscera. Therefore, it was destroyed.
Naturally, they expect a report to come. The report comes, then why viscera is to be preserved?
My lord, my lord.
They presume that you will be filing a petition for CBI investigation so that they should preserve the viscera.
No, my lord.
In case of this nature.
No, my lord.
Then
what I am saying is that, my lord, in such a complicated case, my lord, in such circumstances, may I shoot photograph of my daughter, my lord? The lordship will come. Every entire case is here in the photograph, my lord. When a daughter, my daughter is going upstairs.
That is why we have asked the report of the AIMS. Now the report is there. The AIMS has based its reports on all the material which was provided.
Right, my lord.
Beyond that, what is to be seen? What your allegation is of what? What offence you allege?
My allegation is my daughter has been murdered.
Medical negligence. So if it is murder, then it is not medical negligence.
No, medical negligence, including medical, because my daughter has been murdered, half murdered in the hostel, and thereafter it has been completed in the hospital. It is my allegation from day one. From day one, 161 statement, I have stated clearly, my lord. And I have given the names of those culprits also, my lord. In my 161 statement on 16th of July.
Have the opportunity if the police files a report under 173.
My lord.
Closing the
what-
matter, you will have an opportunity.
My lord.
Yes.
Kindly see that report. Kindly see the
Well, you
photograph.
show it to the trial court. If you show it to the trial court, you convince them there.
No, but
We are not having a look at the matter under 190 of the CR.
I understand, my lord, but
Yes.
but what I am trying to say before this honorable court is that what police will file before the court. They concluded on 16th of July itself that it is a suicide. A girl going upstairs at 10:25 p.m. on 14th of July, and she has committed suicide, whereas the girl fallen on 9:46 p.m. on the same day. How the girl can fall prior to 1 hour? How it became a suicide, my lord? Your lordship, you can see the photograph. It is provided by respondent number 3, my lord.
We are not restricting that. We keep the photograph. We are only
We-
thinking as to
we-
what can
we-
be done by this court.
What is my case is, my lord, let me explain, my lord. My case is that my daughter was half-murdered in the hostel, and they presumed that my daughter is dead. And to just manifest, they admitted her to the hospital. And thereafter, in hospital, she has been given poison. It is my case, my lord. Why I am saying so, my lord?
Why do you attribute that to the doctors in the hospital?
Exactly.
What is the
Doctors, I am
animosity
saying,
of
my lord.
Doctors.
I am saying, my lord, not only doctor, hospital, hostel authorities, hostel owner, hospital, two hospitals and police. Everybody is hand in gloves, my lord. Your lordship, may kindly see page number 30, last page of my IA, my lord, at page number 29. Why I am saying so, my lord? This is the postmortem certificate. Page number 29, my lord.
Yes.
Please. Your lordship, may kindly see under the column right hand side abdomen. You lordship got it under the column abdomen, abdominal wall, nothing particular.
29 of
29 of my IA, my lord. IA, my lord.
IA number
63866.
Yes, sir.
63866 or 25.
It's we notes last time. Is that additional
for direction. We Maheshwari and company are looking for the petitioner. We are supporting for it.
For the sake of our window, lordship, may kindly see, it is my daughter, my lord. If I am cannot.
No, we are
sympathy.
I have
My
sympathy
lord, my
with
lord.
you. We are trying to examine it. This is not the first day. We've been dealing with it for the last at least a dozen times. Yes, page 29. What do you want to show?
Your lordship, may kindly see. Under the column abdomen, my lord. Stomach and contents, my lord.
Yes.
About 80 grams of brown, yellow and white mixed semi-digested rice food noted. Mucus congested. Suspicious smell noted, my lord. Your lordship, may kindly emphasis on the word suspicious smell noted. My daughter had her food at 8 p.m. on 14th of July. She has been declared died on 16th of July. Still, there is a 80 ml of yellow, white mixed and digested rice food noted. And my lord, metabolic time for the digestion is 3 hours. That's why I wanted to show this diagram, my lord. This is the body anatomy of a human body, my lord. This is the esophagus, stomach, and thereafter small intestine, large intestine.
What does the viscera report say?
Nothing is with me, my lord. That's why I have taken this IA.
My lords, we will file, but we have it. It's part of the case diary. And as my lords noted, the viscera examination was done. No poison. It categorically states no poison, no drugs, no alcohol. And thereafter, only as per the procedure, my lords, viscera was not preserved. My
Tell us, how do you explain?
Yes,
whether she was given solid food during the time she was admitted in the hospital. She could not have. She was a patient of severe brain injury.
Yes, my
How could she have consumed solid food?
My lords, we will get instructions on that.
All right, you come after lunch, we will take it up. Post lunch.
Where is Mr. Patwalia? Yes, Mr. Mehta, what are these two matters?
Lord, these are these matters regarding High Court building.
Yes, what is
Lord,
your tell us.
yes, Lord, let Mr. Patwalia begin.
Let Mr. Patwalia.
I would like,
We had appointed him.
Lord,
Our request that he was there.
yes, so far as the first matter is concerned,
Yes.
Lord, in both matters, my Lord, so far as the parking is concerned, there is a need for parking. There is no difficulty. We are not objecting to that.
And in the other matter, there is a need for a little shelter. That's all.
No, Lord, then the difficulty is, my Lord, this is a World Heritage Site. Lord,
Now, the enclosure, Mr. Gupta, please show the photograph to Mr. Mithouse.
that I have seen that. But that was in existence when the World Heritage Site title was conferred. But we can do nothing at the cost of that title being taken away. Let us take the permission.
Instructions of the High Court, finished. Direction of the High Court, you comply with it.
But that doesn't bind the World Heritage Committee.
Very well.
Lord, the High
How
Court.
does it matter? How is the World
It
Heritage
matters to the nation.
What?
The High Court should not have done anything, my Lord, which takes away, which has the.
How long
Then, my Lord, allow me to
does
answer.
the committee take to
Lord,
respond to your communication?
I'm sorry, my Lord. If suppose High Court says that tomorrow that change the position in Taj Mahal.
No, it's not
And
that.
if Taj Mahal, my Lord,
Exactly that practice.
Lord, then I would like to, my Lord, argue them.
Yes, you please argue. We want you to argue the matter. That's why we are called you.
Not today, my Lord.
Why?
Not today, my Lord. I was called, my Lord, and therefore my High Court is more eager, my Lord, than the bar. It is for the bar, but bar is, my Lord, also not.
Bars keep changing, you know.
My Lord, High Court also.
Presidents keep changing, the executive committee keeps changing, and everything keeps.
My Lord, the Honorable.
My brother.
Given an example of what happened in
What
Rajasthan.
happened in Rajasthan?
One protest from the Bar Association resulted into the building being delayed by 16 years. So,
fact specific issues, my Lord, your Lordships are right. I bow down. But, my Lord, the country would not like to lose the World Heritage Site status merely because, my Lord, two honorable judges feel that there should be a change.
You are not denying that the requirement of that shelter is going to help everyone?
I do not, my Lord, nobody wants. Lord, my Lord, let me not take, my Lord, an adversarial stand. Let me take permission from the committee and do it. I would not, my Lord, accept.
How much time will you take to take the permission from the committee? Since when have you applied to the committee and the committee is not responding? If the committee doesn't respond for 100 years, what do you mean?
We have applied. We have applied. We'll expedite the, my Lord, process.
When did you apply? We want
Lord,
to
immediately after the High Court's order.
When do you want this matter to argue? You want to argue this matter? When? You say you don't believe to difficulty in arguing today. When would you like to argue?
There is a special bench at 2.
All right.
In court 3, my Lord. That's
We are
the
asking you when? Tomorrow, day after, Monday, Friday?
next week, any day.
Tuesday, next Tuesday?
Next Tuesday can be done. And I would request, my lord, High Court also can't take an adversarial stand, my lord.
Yes, sir.
It's
Absolutely.
equally
It's a matter of-
important for the High Court as an institution that the building doesn't lose the status.
So Mehta, what they are saying is that water comes in during rains in the courtrooms because of this small shelter not being there. See the difficulty, it's apparent.
High Court has no personal interest in it.
Anomaly is apparent. The 9 courts have that veranda and 1 court doesn't have. What's the logic?
My lord, I'll, my lord, address on that, but I would request High Court not to be adversarial. They will also try not to be.
I'm not saying a word.
Court come and appeal. High Court doesn't.
Court
You have
has-
taken it adversarial.
Lord, High Court has done what High
You should
Court.
ask that, Mr. Mehta, you should ask that question to your client, please.
My lord,
You-
High
you
Court
have
has
taken-
directed us, my lord, it would not come in the appeal. High Court is,
Administration doesn't want any direction from the High Court. It is
no.
egoistical.
We are bound, my lord. I'm just answering why High Court has not come. High Court would not come because it's
No, that's
that
what
order
you have taken.
under
Don't-
challenge.
Don't put that to the High Court, that High Court is adversarial in this matter.
No, I'm
High Court is not
requesting him not to
adversarial.
be adversarial.
High Court is-
I'm not even saying a word.
High Court is trying to look out for the interests of the litigants and of course,
I'm
the
sorry, but I'm-
courtrooms itself.
But I'm sorry, your lordships have not, I could not convey myself.
We'll-
I
we'll
said
let
my
you know.
learned friend may not take adversary.
He is not at all. And
Then my request is accepted by him. High Court doesn't come into the picture.
All right.
But
Next
my lord,
question.
my lord, very few buildings have national heritage, my lord, the World Heritage
UNESCO heritage.
tag, UNESCO Heritage tag. My lord, nothing should be done, my lord, in my respectful personal my lord, view, which my lord, takes away that tag from our country.
Always convince the UNESCO.
That we will
that
do.
This is a requirement.
That's the
need of the hour, and therefore we have done it.
That's the
Without
only.
changing the total facade or
No,
anything.
that's the only thing I am requesting.
Huh.
That let us do it after taking their permission. That's all.
What steps the Chandigarh administration has
Not
taken so
because,
far?
my lord, there is a mandamus, but mandamus also, my lord.
Mandamus has not come like that. The court had been monitoring it for dates after
I'm
dates
not-
after dates after dates.
I'm not.
Preemptory orders.
And thereafter, if the Chandigarh administration sleeps over it.
No,
then
we are
there's-
not sleeping over it, but I'll show.
That's what we will examine for the next day.
Yeah, please examine. And I am not opposed to the idea, but not without the permission.
On the request of Mr.
The bottom line is we
MEHTA.
cannot lose the tag of World Heritage Site, UNESCO Heritage Site.
That is Solicitor General. List this matter again on next Tuesday, 29th April 2025. To be taken up immediately after the fresh matters. And one matrimonial matter we have fixed, no? नहीं, matrimonial matter fixed है? नहीं, वो specific performance वाला क्या Mr. बढ़िया. हाँ नहीं, immediately after fresh कर दिए. One by one हो जाएगा. एक को file में.
The parking matter, my learned friend said he has no difficulty. So
Yes,
that,
understood.
so that may be left out. Mullah, because
On that
No,
next
I am saying not without permission from the. Do this. Don't do that. I just now told you 5 seconds back. 5 minutes back.
you said that.
That I have no, I am not objecting to the parking requirement, but not without permission from the UNESCO Heritage
UNESCO
Site.
doesn't need to give permission for that. Not at all. That is not required.
When I am saying it's required, my lord, there would be some responsibility.
hear you on that also.
Just 5 minutes back,
No,
my
but
lord.
there is no such
Therefore,
requirement.
there was, my lord, there was a purpose why I requested him not to take adversary.
No, I'm not taking.
We had a discussion, my lord, on 10 minutes.
You also provide a copy of your today's petition to Mr. Patwalia.
And to me, and to me.
Ask your
I don't have the
AOR.
second.
I will provide you everything.
Very
But you are the God, my lord. I can't.
Mr. Patwalia also he was wanting.
Certainly, your lordship, sir, my lord Justice VIKRAM NATH is aware, bar was not taken in confidence when Gujarat High Court building was made.
And that's one of the worst buildings there.
Exactly. I didn't want to say that. I didn't want to say that.
I wanted the architect to be sent to jail.
even in Rajasthan.
Whoever selected the architect who designed the High Court building at Gujarat, Ahmedabad, should be sent to jail.
Lord, I will tell your lordship.
You must be a party to all that.
No, I was. It was 98, 99.
Still you were.
No, my lord. I went in one of the meetings as a driver of my senior.
My lord.
He couldn't drive. So he said, I was not invited. But my senior was invited. He couldn't drive. So he said, you take. But, my lord, your lordships will be shocked.
Great degree of satisfaction.
The lawyers have nothing to do with the design of the building. It is the architect who is responsible.
Exactly. My lord,
Don't say that because lawyers were not consulted, therefore that building has come up like that.
He could have said that this is
Lawyers are
not.
not architects.
My lord, when we were called, ultimately after the building was made, the architect explained to many senior lawyers, Mr. Shetna and Mr. Vakmai senior, that I have provided for, that I have huge space available, why not to have a bar room? And everybody blasted him that in a High Court building, bar room is an essential part, not that you are doing a charity.
Yes, yes.
So therefore I say that architect should be sent to jail.
Your lordships would be surprised when we shifted, the registry of the court gave us maps that from court number 1 to court number 15.
Mr. Mehta, Rajasthan High Court building is not like that. Everyone is very happy, very satisfied. The situation prior to that is that if you park in the old building, which is again a heritage building, if you park your vehicle at 10:30, you couldn't get it out before 5:30. You were stuck there.
And the new building is
Yeah,
completely the opposite. It is more
We used to, my lord, complete our board with the map. That now 1 to 9 we will have to go down, then take a lift, then walk, etc. etc.
So that is a SOP.
And when it was, my lord, inaugurated, Justice, my lord, the then Chief Justice said that it looks more like a fort than a court. Obliged, your lord.
एक बज गया कॉल कर दी किसी को टाइमिंग चाहिए तो
22 minutes.
Yes.
This matter, Manoj, we settled at mediation. Matrimonial dispute, Manoj.
We have filed the joint application for divorce as per settlement.
So, Lordship's convenience, Manoj, one chart is being drawn out pending litigation and what is to be done inter se.
Right.
Manoj, may I circulate?
Sir. Both sides are here.
Both sides are here.
Settlement arrived at terms complied with.
No, no.
Or to be complied with.
Part compliance to be complied with within 60 days. Last 2 pages, Manoj, I've drawn a tranche. Page 4, your Lordship may have. Bottom says obligations of the party.
Yes.
So this first is done, Manoj.
Okay.
20 is handed over today, Manoj. Remaining within 60 days is the next stage.
No. 10 lakhs you have to pay
through DD. 10 lakhs DD, Manoj, handed over. 10 lakhs worth of gold ornaments, Manoj, handed over.
Handed over.
That part's done.
Then number 2 is from 22nd April 60 days.
Please.
15 lakhs and gold worth 19 lakhs.
19 ornaments worth 19 lakhs.
Third one is.
And then third is 36 posted checks.
That happens on the same day.
On the same day.
Please.
Within 2 months.
Within 2 months.
Maybe listed out of two.
IA number
98032.
9803225 2024.
98032.
Just a second, I'm still pending.
Just
one request, Manoj.
Yes.
While quashing, Manoj, the matters inter se the parties, your Lordship may add a line by inter se the parties as well as their family members. She's the complainant and all, let that family members work. That's about it. And divorce, Manoj, both of them.
No, you have given the details of the case.
Yes, yes,
Details are
All
given.
these cases will be quashed, finished.
Yes.
By the parties as well as their family
This
members.
is an entirety.
That's about
This is directly complete.
Please.
Yes. Allow for the
Deep
to be quashed.
Your Lordship,
What has पहले किया है? Decree to be drawn only after complete payment is made and proof of deposit is filed before the registry.
Your Lordship, Your Lordship.
And cases to be closed after thereafter.
Your Lordship.
Item 25. Sir, my learned friend Mr. Goyal is here. Lord, I'm in a special bench in court 3. My Lord, there is a special combination sitting. Can be kept, my Lord, after 2 weeks.
25.
25, my Lords.
3 matters.
Yeah, yes.
Request I had, because I made it on the last occasion also. The High Court had directed an inquiry. The solicitor said that he will take the report of that inquiry. He has filed a reply stating the essence, but that report has not come.
Report, No, no, you can't file an object. Let it be argued.
It's already passed, but we are not hearing arguments. Are
Yes,
you
sir.
giving an adjournment or not?
No, I'm just saying that please give
We will consider all that on the next day.
Yes, sir.
Your Lordship.
We don't know what it is. He doesn't want, he wants to file it or he doesn't want to file it. Whatever it is, we will hear it on the next day.
Friend said that he filed it from the.
No, no, I have seen.
He says he never said that.
No, no. Lord, I have seen, my Lord, the report, my Lord, there is nothing secret in the report, but strangers can't sit in appeal over it of a former judge of the High Court and say this is the difficulty. We appointed a judge of the former judge to examine everything.
Second on next Tuesday.
No, not next Tuesday, next to next, if you like.
Next to next. It's all right. Next to next Tuesday is 6th.
Lord, instead of 6, can it be on 9th, my Lord? The 9th would be a final hearing table.
So July.
9th is Friday.
This can go in July.
July was.
I think this can.
Before vacation, I want a copy of the report. I'll be able to persuade your lordship that.
But there is nothing, my Lord, it's a matter of inquiry, my Lord. It's
Whatever it is, at least he wants an opportunity to argue. You are seeking adjournment. We will fix a date.
So next week, my Lord.
Next week. Very well. Next week. 29th.
Your Lordship, may I please mention an urgent matter?
Now we'll come back.
Your Lordship, there is urgency of demolition, Your Lordship.
Demolition.
Your Lordship, 1 minute, Your Lordship. Your Lordship heard the matter on 17. Your Lordship gave the liberty to go back. The slum rehabilitation matter, Your Lordship. 22 tribal people. Your Lordship gave the permission to go back. We filed review. Review was heard today and it was dismissed, Your Lordship. Your Lordship, I am filing. They have not granted any stay, Your Lordship, further stay. The bulldozers are outside. They are demolishing within half an hour, Your Lordship. Your Lordship, I will file the MA in the disposed of matter. Your Lordship, may I hear it on hear it at 2 o'clock, Your Lordship, because all the properties.
Orders on oral request. No.
If I may mention, item 24, Miss Meenakshi Roda has fallen ill. She was on her legs and port 4 has been rushed to hospital.
What
So
happened
I'm
to her?
24.
What happened?
I'm here. I was
Mr.
told.
Mehta was appearing for the other side.
No.
No, I am appearing not that great.
My
No,
lord,
in that case.
yes, my lords, the society, the home buyers. My lord, she was in court 4. She has been right now rushed to the hospital.
No, no, I was not appearing opposite. My Lord, in that case, I would have fainted. With this combination, I would have fainted. I would like to
When do you
know
want
who she was opposing.
When do you want it?
My lords, next week, my lords.
Next week. Next Tuesday.
Item 20.
Hey, you will not let us go. What kind of bar is this? Is here anybody who knows about what happened to Miss Arora? Is she all right? We were informed that before lunch that she fainted or something happened in the courtroom. Taken ill and she was rushed to the hospital. None of you know. All right. Yes.
My lord. My lord, let me start by making a submission of one line, my lord. As per police, concerned police station, a girl going upstairs on 14th July, 10:25 p.m. having a
What is
dress.
the basis for this statement of police?
My lord, I'll complete and then your lordship will get everything, my lord. Having a dress up to knee, white color top. And they are saying this is my daughter and she has jumped from terrace and thereby it is suicide. Another photo supplied by the same police station, the girl lying downstairs in the basement at 9:46 p.m. 14th July. That's why I wanted to show this photograph, my lord. This photograph is disclosing everything, my lord. 9:46 p.m. 14th July, that girl is lying downstairs. And
Has
she
fallen down from the terrace?
Yes.
According to them.
According to them. It is 9:46.
So according to them, one stand is that she had jumped from the terrace before 9:46.
No, 10:25. एक घंटा पहले. एक घंटा पहले सर.
9:46 पे the body is found on the floor,
Yes.
on the ground floor.
My lord.
Then that means she had taken the jump prior to that.
Prior to that. And, and another photograph they are showing she has gone upstairs at 10:25.
All right.
Now, my lord, how it is possible, my lord? Your Lordship, kindly see the photo. It is supplied by police. I am not. It is not my photographs, my lord.
Take the pictures.
These entire photographs will disclose the entire case, my lord.
Please give us also, sir. Excuse me.
Yeah. So,
This is from CCTV.
This is CCTV footage?
yes, my lord. It is supplied by police. It is on the record of the Andhra Pradesh High Court, my lord, in a hard disk.
22/25/94.
My lord.
14 July, 14 July, 22/25.
First photograph, a girl going upstairs. You lordship may kindly see the dress up to knee, white color. And second photograph, your lordship may kindly see girl fallen down, having a t-shirt and half pant. And t-shirt is a blue color. Your lordship kindly see. It is supplied by police, not my photograph. And that timing, your lordship may kindly see.
Just tell us, we don't know about the position of the building, etc. How could this body be here in this lane? It's not directly accessible from the top.
Exactly, my lord. It is next building, my lord. It is
Which is the body? Which is the body as per you in this? We don't understand. This doesn't not very clear.
Yes, my lord. It is supplied by police, my lord.
No, but how do you say that the police are claiming that the body was lying here in this passage?
I am not saying it is said by police themselves.
Where?
And thereby they made it a suicide case.
Photograph, as per the police, where do you suggest that they have shown the fallen gun?
It is like that, my lord. It is like that, my lord. It is for police. They are saying like that. 9:46 p.m. She is lying down in a half pant and t-shirt, having blue color t-shirt.
Blue color t-shirt.
Yes, my lord. At least that can be seen, my lord. And 10:25 she goes upstairs in a white top.
But how could she have committed suicide, fallen here from the terrace?
And that is also next building, my lord. Not this building.
This is the next building.
It is next
Do you
building.
have any description?
Distance.
Any description anywhere which shows that this is the photograph of the body lying there?
Nothing, my lord. Nothing. That's why I am here, my lord.
Wait. mentioning this fact from that this photo pertains, or police has claimed that these two photographs.
Exactly.
Where?
Police
Where do we get it from?
in their case diary have they mentioned anywhere about these pictures?
In their reply, they does not speak anything about this, my
You are
lord.
saying that these are the pictures.
But this photograph has been circulated to the court commissioner on the order of the Andhra Pradesh High Court, and the Andhra Pradesh the court commissioner submitted before the Andhra Pradesh High Court.
Must be some rough sketch or memorandum prepared regarding these photographs.
My lord, I have nothing to say, my lord. I have nothing, my lord. That's why I am here. I don't have viscera report. I don't have forensic report. I don't have the opinion of the doctors which the committee was formed by the police, 6 doctors committee, to know the cause of death as well as the medical negligence. So what I am praying here, my lord, to know the opinion of 6 doctors committee that which was supplied to AIMS to form their opinion, and the viscera report. This is my idea, my lord.
All right, Likhiye.
My lord, one more submission before your lordship dictates. The dress of my daughter has been destroyed by the respondent number 5.
Who is respondent number 5?
Respondent number 5 is Venkatarama Hospital, on whom my daughter was admitted on 14 July at 10:30 p.m. And I have the videograph of my daughter. On my deputation, my friend's driver visited the hospital at 1:15 a.m. on 15 July. She is talking, she is asking for water, she is asking the doctor, I want to talk to my father. I have the videograph in the pen drive, my lord. So, my lord, my daughter was speaking at
You have
1:15.
mentioned all this in your petition?
My lord?
You have mentioned all these facts in your
Everything is there, my lord. And there is no denial. I have clearly stated that my daughter has been murdered by respondent number 5, respondent number 3, respondent number 7, and having hand in gloves all together. And if it is false, my lord, they would file defamation against me right up to now. I am claiming this since 2003 in the Andhra Pradesh High Court as well as here also, my lord.
All right.
They did not dare to file defamation against me. And I have time and again stated, my lord, that my daughter has been poisoned in respondent number 5 hospital. And that's why her that food is not digested, my lord. 3 घंटे का टाइम लगता है सब खाना पचने के लिए स्टोमक में.
हॉस्पिटल वाले क्यों पॉइजन करेंगे बताइए हमको, why would they?
Because my lord, of the record, let me say, in the hostel there is some illicit relationship going on with the hostel owner or with the students. And my daughter was knowing everything. And she was like my nature. Every time it is protestive. And before to that incident, my lord, her 6,000 rupees has been stolen from her purse. So she was hesitating on that. Therefore, she has threatened the hospital authority that if you don't return back my amount, I will tell everything to my parents. And my uncle is a Bombay High Court advocate. It is my submission of the record, my lord.
My lords.
So what I am saying today here, my lord, that opinion of that 6 doctors, what they have given, because my lord, another statement I am making of the record, my lord, one of the senior most doctor in the panel, he came out after examination because I was also there, my lord. I was also called for that inquiry on 19th of September 2023, my lord. So after completing the inquiry, he came out and informed Mr. Shah, your daughter has not been died because of that multiple injury. What is shown in the autopsy report, the reason is something different. That much he has informed. I don't want to disclose the name of that doctor. It will come under 311 before the trial court, my lord. It is something different. And different, what, my lord, that suspicious smell, that viscera report has to disclose about the suspicious smell. As on today I am blank, I have nothing. At least as a father,
Already.
Petitioner Sukhdev, so what's your good name?
My younger brother, my lord.
Okay.
My younger brother. His daughter means my daughter, my lord. DNA is same.
Yes.
I am residing in Bombay, he is residing in Kolkata, and daughter was in Andhra Pradesh.
That is a make.
All right. JK heard counsel for the parties, order is reserved.
My lords, since a query had fallen from my lords, just one thing, my lords, on the aspect of undigested food, my lords, in a state of coma, digestion is delayed. In a state of shock, my lords, may I just hand over Modi's medical jurisprudence on that?
Undigested rice can't be.
40 hours, my lords, that's what Modi's medical jurisprudence says. But
Right.
behind my lords.
Very good. Thank you.
Obliged.
Obliged.
What had happened to her? She fainted? Fainted.
What is not possible?
Which court number? Court number 4. And who was the counsel for the other side?
Spontaneous liability.
Excellent. But now she's all right.
She has gone back.
All right. Yes, next.
Lordship. Milords, despite the contempt, the money is not
Lordship.
forward. Milords, I am saying with greatest respect, Milords, because she has been coming time and again and there is no money coming forward. Milords, my client has lived with the husband, Milords, for 10 years. Milords, kindly send him to jail for a month. The entire money, Milords, will be coming forward in a go. With respect, Milords, since I have been
All right, all right. Hey,
Lordship, please.
your item number is?
35.
35.
Contempt is already issued, Milords.
All right, all right. Wait.
Last time the council had informed your lordship that Milords, when your lordships directed that to bring the toothbrush, etc. Lordship Justice Mehta.
Just 2 minutes.
In that, in Milords, the Mr. Manish Gupta said that he is ready to make the payment. Milords, Milords, I say it on oath.
Just please, 2 minutes. Let my lords go through the order.
Yes.
Lordship, just before yesterday, I was informed that the petitioner has suffered a brain stroke, Lordship. He is admitted, respondent, sorry, Lordship. He is admitted in ICU, therefore, Lordship, he could not appear before this Honorable Court, Lordship. Lordship, on the last date, Lordship, I have stated that he is ready to pay 10,000 of maintenance. And Madam is saying, I was telling I was petitioner.
Milords, I don't tell lies.
No, everything is recorded in the order. We have said that he has to come back and tell us how he will make the balance payment of 20 lakhs, how much time he wants, in what manner. And further, he will come ready with a further amount of 5 lakh rupees. That is the order. There is no statement of the council recorded regarding that he is ready to pay the 25 lakhs. The statement of the respondent is recorded that he is drawing 27,000 as pension and he is willing to give 10,000 per month to the petitioner. That is recorded in the order. All right. Now, he said that his client has fallen ill. देखा भाई कहाँ brain surgery? Stroke हो गया. Super specialty hospital. Orba.
Milords, he is a moneyed man, Milords. With respect,
Wait. We have heard all this on the last occasion. Thereafter, we had passed the order.
Lord, I'm so sorry.
condition, it is difficult for the council also to get anything and for the court also. If he is hospitalized in ICU with a brain stroke, some time will have to be given. We'll fix this matter after 4 weeks and get a fresh status report about his medical health. This address
Copy of
given.
this so that I can also verify that whether he's
Yes.
in ICU or not.
Yes, sir. We'll provide you. We are mentioning everything in the order.
Lordship, please.
So you can verify it from there.
Lordship.
You don't need a copy of this report.
No, it's very
Yes, yes, we'll mention that.
I will give it. Give a copy right.
Give a copy to her.
I do not have, I will give it.
I will have to ask from him.
No, I will give. We will give you one copy, madam.
Take a
Please.
snap out of it. Take a picture of this.
You may not have to ask him.
Take a
photocopy.
photocopy phone. Scan it from the phone immediately.
No, they have a copy.
They have photocopy it.
आप order लिखिए.
Lordship, one thing I want to say, Lordship,
हाँ.
I should not say, Lordship. In a legal aid matter, why I was seeing first time Madam is saying so
Madam
much.
always argues like this. With full sincerity, with full heart, nothing she leaves.
No, she should also understand.
It's not her concern. She is a true advocate. So don't make any comment on that. I've heard her many times.
You should try to learn from her.
The commitment to the profession.
For the profession and the clients.
Fighting for justice for your client. That's what she's doing. Truly, nothing. No adverse. Yes. लिखिए भाई. On 4th April 2025, we had passed the following order. Quote कर दीजिए. Today, when the matter is taken up, you are Mr. Manish Gupta.
Yes, please, Lord.
Mr. Manish Gupta, learned advocate, appearing for the respondent husband, has placed before the court one certificate issued by New Korba Hospital, Mangalam Vihar, Osabadi, Korba, bracket में Chhattisgarh, dated 20th April 2025, and further a CT scan report of GB Diagnostics situated in Korba. So, according to the certificate of the hospital, the respondent Arun Kumar Das, son of Mr. Dev Das, aged 62 years, male, resident of B-136, Urja Nagar, Dipka, is admitted in ICU in the hospital on 19 April 2025, having weakness in right side of body with slurred speech and deviation of mouth, and was diagnosed as a case of CVA, capital Z, dash ischemic stroke with hypertension and diabetes. Full stop. The CT scan report suggests variable sized hypodense lesions. ये ऊपर वाला प्रोग्राम पर पॉइंट जो है ये कोट कर दिएगा. ठीक. Mr. Gupta, learned counsel, thus submits that in view of this development and the medical condition of the respondent, firstly, he is not present today. Secondly, he has not received the draft of ₹5 lakhs, and he has no further instructions with regards to the mode of payment of the balance amount of permanent alimony. He has prayed for matter being adjourned and to be fixed after 4 weeks at least to enable him to obtain further instructions with regard to the medical condition of the respondent.
Please.
So, a copy of the certificate of the hospital dated 20th April 25 and the CT scan report of 19th April 2025 are provided to the counsel for the petitioner so that the petitioner may also verify and find out about the true status of the respondent. Let this matter be listed again. On 21st May 2025.
Much obliged.
I am for respondent number 2, and outside I have a technical submission if will also allow me to say.
Item number
23.
23.
May I?
Yes.
My lords, petitioner has made respondent number 2, Mr. Umesh Mishra, party as a private party. And when the matter was in High Court suggested then that the police station should be made party instead of the IO in person. And they have filed an amended application to that aspect, which is still pending. Now, their difficulty would have been if they changed the memo in Supreme Court, the matter could not have been listed. Now, my lords, I could get transferred or this investigation could go out of my hand in case this case gets prolonged. Then I suggest that infirmity could be rectified here also, and the Criminal Investigation Department, Gwalior, could be made the respondent number 2 instead of party.
My lord,
Because the ATR needs to be filed and a private counsel will not be able to assist the court the way state counsel could have.
You are not appearing for the state.
I'm appearing for the state.
State is represented. What is the problem?
My lords, he's for the chief secretary, but the ATR is
the state principal secretary. You will be representing every department in the state. Why you are taking this?
I bow down to my lords.
So the state has filed its counter affidavit notice. The present application now is only for the limited purpose of grant of bail that the other side is seeking. In the counter millers, we have indicated there are multiple antecedents millers. Entire chart has been provided. There are 14 cases against him.
In how many of them were they recovered, registered after his arrest? Tell us.
Yes.
Wait a minute. I have some idea about the background of this caste and how the people are entangled in cases. Mr. Joshi.
Please,
Let me tell you, the adjoining areas of Udaipur, Banswara district with MP, there's a rampant practice to involve these people in as many cases as you can. Tell us, where is the chart?
Yes, page 8 of my counter affidavit. Para 8.
It shows the dates. When
Yes.
was he first arrested?
Yes, please.
Is he named in any of the FIRs? He would not be. There must be all FIRs of theft, so far as my information goes. Mostly theft, or then you have that weapon of 399, 400. 5 आदमी बैठकर बात कर रहे थे. Standard practice. Yes.
At page 10 also.
What is the relief you are seeking now in this petition?
My lords, the primary relief we are seeking in the petition is that the petitioner be granted bail in the cases in which he is presently in custody, in which he was
Who is
arrested.
the petitioner? Petitioner is not Gangu.
The petitioner's Gangu.
The mother and the.
Is it a habeas corpus petition you are filing?
No, my lord, the petitioner is Gangu's wife. What happened is we were filing the petition before the High Court also in Gangu's name. However, in fact, I have pleaded that in the petition and attached the local advocate's affidavit. The prison authorities, my lords, went out of their way to stop the advocate from getting Gangu's signature on the affidavit. In fact, subsequent to that, he was taken out of prison and beaten up, due to which the High Court passed an order transferring him to outside Guna district to a different prison.
Is he the brother of the
The uncle of
Uncle
the
of-
deceased.
uncle of the-
He's the uncle of the deceased and an eyewitness. My lords, the startling thing is the magisterial inquiry report holding that it is a homicidal death. The report was signed in September of last year. An FIR was registered. We have an eyewitness, my lords. However, it just says 7 police officers. From September 24, we are now in April 25, my lords. Not a single police officer has been arrested. There is an FIR under 302, my lords. After that, they were serially arresting the Gangu.
Why have you pleaded respondent number 2?
My lords, he was
The main allegation is against him.
No, my lords, respondent number 2 was the IO who was supposed to investigate the FIR into the homicidal
Custodial
death, into the custodial death. Therefore, we also pleaded respondent number 2.
No malified allegation.
No, except that nothing is happening, my lords.
That's
No
right.
police officer has been arrested. They have been
Mr.
seized.
Joshi, you are appearing for?
I'm for the statements. Respondent number 1.
Commissioner of Police and your Home Secretary. Call them. When?
Because I'm here to assist Mullahs.
No.
If any instructions are to be taken, we'll take Mullahs.
What instructions you have today, you tell us? What is the status of the FIR investigation and?
Why not a single
No, sir.
assailant has been arrested till date? There's an eyewitness, no dispute?
Yes, Mullahs.
Why not a single of the assailants has been arrested till date?
I'll take instructions on that.
Then keep your-
Because the impugned order, High Court has made some arrangements. Your Lordships have seen the impugned order.
Arrangements, what arrangements? Shifting him to another prison?
No, that is as far
That's
as,
not an arrangement which is
that is
required.
because as far as he apprehended that there would be serious concerns about his custody or he being
The High Court.
the police trying to hit him. Now, Mullahs,
Is safety inside the jail.
yes, Mullahs.
Because
That's right, Mullahs.
there is issues of his safety inside the jail also.
That's right, Mullahs. Would my lords kindly see, yes, Mullahs, page 3, Mullahs, para 5, how the High Court has dealt with Mullahs. Investigation is also transferred, Mullahs. Para 5,
Different to the original FIR, how does the High Court deal with that? Of homicides?
may I just place Mullahs para 5 onwards, Mullahs? The picture will be slightly clear, Mullahs. Having considered the manner in which the police proceeded in the case, this court finds that it is the case in which definitely investigation should be monitored by the Superintendent of Police Guna. The court would also like to observe that it is a case where accountability of the senior police officer may also be required to be fixed administratively. This court is of the view that the investigation conducted by the CID should be monitored by the SP Guna, and the SP Guna shall submit status report to this court. So, Mullahs, status reports have been called.
Said about this in the counter. What is the status of investigation as on date?
Mullahs, the present, Mullahs, on that, Mullahs, there is nothing.
Apparently.
Mullahs, because only bail is being.
Reasons are writ large.
Mullahs, in the present petition, Mullahs, only the bail is being pressed, Mullahs.
1 minute. Read
The
paragraph
present
3 of the
petition.
High Court order.
SLP is before us, Mr. Joshi.
Yes, Mullahs,
They may be pressing for whatever they are. The facts are there.
And we are not going to close our eyes to all this.
No, Mullahs.
You read paragraph 3 of the order.
Yes, Mullahs. Para 3.
What has the ministerial inquiry found and what have you done after that?
So-and-so is brought to the notice of this court that the report of the magisterial inquiry and has argued that in the said inquiry, Inspector so-and-so, Constable so-and-so have been directed to be made accused in relation to the custodial death of their party, and accordingly FIR has been registered against them.
Now there is a named FIR on the basis of an inquiry conducted by the magistrate.
Yes.
This is stand of
This is
state
stand of
government.
the state government. And still nothing has been done. According
Mullahs,
to
I'll take that's according to her, Mullahs. I'll take instructions whether action has been taken or not, Mullahs.
Friday को देते हैं. All right, Friday.
Friday I'll take instruction.
Okay, very serious allegations have been made.
Because without saying
No,
anything,
just one
Mulot,
line.
I'll come. I'm here, Mulot. On
Well,
Friday,
one
Mulot,
line.
everything will be indicated, Mulot.
Very serious allegations have been made against the police administration of the district, that despite there being a named FIR under section 302 based upon an inquiry report by the magistrate, although FIR was registered, but no further action has been taken on the same, and no arrests have been made. Full stop. Shri Nachiketa Joshi, learned senior counsel appearing for the state of
Madhya
Pradesh, seeks time to obtain instructions in the matter. नहीं, उसके बाद देखिए, we were inclined to summon the Director General of Police and the Home Secretary of the state when Mr. Joshi made a request that 2 days' time may be granted to obtain instructions in the matter, and thereafter the court may consider calling the officers to stop. Release this matter again on Friday. Mr. Joshi to obtain instructions in the matter. Next.
Please. Oblige.
May I please? As per my lord's instruction, I filed my affidavit along with the pay slip, my lords. And I also filed an application under 142 to grant divorce on the ground that the marriage has been irretrievably broken. So the marriage happened in the year 2009, my lords. The date of separation is in the month of July 2010 itself. We've been fighting.
24.
26, my lords. Item 26. I'm so sorry, 26, my lords.
One.
Separate. I filed a cruelty petition before the family court. It was decreed, reversed by the High Court in civil miscellaneous application. And thereafter, my lords, I filed an SLP notice issued for mediation. Now the marriage has been irretrievably broken. I have also filed an application under 142, my lords, requesting my lords to invoke Article 146, my lords. I'm willing.
So your total gross salary is 2,20,000.
Please, my lords.
And after deductions of 70,000, you take away home takeaway is 149.
149, my lords.
1.5.
And I have a wife, two sons from the second marriage. Second marriage was done after the 139 days from the date of decree of divorce, my lords. Because my instruction is that he's paying 40,000 for.
Respondent is also working?
She was working, but her affidavit says she's not working as of now. She is a postgraduate, a chemical engineer. And I'm told that she has some assets. I'll leave it to your lordship. I'm ready to pay some lump sum amount.
What?
Because my instruction is that 25 lakhs, my lords. Okay. My lords may give me any reasonable amount. I'll
children out of the.
One son.
He's with the mother.
The child is with the mother, my lords. They have filed recently on 2020 in the year. They filed.
How old is the child?
The first son is 15 years old, my lords.
15 years.
Yes, my lord. Lord, what they have filed pay 7, my lord. Only a pay slip, lord. Not, that is not in consonance with your lordship's order, my lord.
All right, we have seen that.
2004 till 2001, my lord, 15.
It was our mistake. We did not mention Neha versus Rajneesh. What is that?
Yes, my lord. But that they should have done.
They have taken advantage of that and
Yes,
they have filed only the pay slip.
Absolutely, my lord.
That is mistake committed by effect.
I won't say, my lord,
That
that
is not file a proper affidavit of assets and income.
2004.
This is not required. You know that. Or you are not aware of.
Only one property he purchased in his second wife's name. All other properties are in his parents' name. As in section.
You mentioned this in your affidavit?
No, my lords.
No, why have you not mentioned this?
Lord, 2004 till 2015, my lord, he was in USA, my lord, earning $12,000 per month, my lord. My lord, I have stated, my lord, I have given his biodata also, my lord, wherein he has mentioned, my lord, if my lord sees my reply, page 19, my lord, his own biodata, my lord, in 2009, he was stated to be earning, my lord, $6,000 at that time, my lord. 2012, he got green card, my lord. If my lord sees page 19 of my counter affidavit, his own biodata, my lord, salary $6,000 per month. Thereafter, property, my lord, 2 houses in Vellore, 2 housing plots, 1 shopping complex, owning a car. Now, thereafter, my lord, page 20, 2004, he is earning, my lord, in USA, came for the purpose of this case only, my lord. He will go back again, my lord. So what that has been given a complete eyewash, my lord.
Totally eyewash.
Yes, my lord. Page 20. Yes, my lord.
2013 he came.
Surrender.
2013 he came back, my lords. Green card expired. He's now working in a company in Hyderabad, my lords.
This is all.
The assets have not evaporated. What he accumulated.
These two properties are family ancestor property, my lord. I'll file an affidavit to that effect, my lord.
And para 46 High Court's order, my lord, merely he has married second wife, my lord, without filing a caveat. That is not a fait accompli, my lord. I am, my lord, on my miseries, my lord, he has, my lord, married during, my lord, that time, within, my lord, 101 days, my lord.
I am at your lordship's hand, my lords.
I did not file even caveat, my lord.
My client, whatever it's falling for my lords, I'll instruct my client, my lords. I'll file.
My lord said issue no.
Any amount is my lords indicating, I'm ready to pay.
Caveat is his discretion. Why should he?
That I understand. Only within, my lord, few days, my lord, he got married, my lord, and I have been told, my lord, that he was living with her, my lord, and in May 2017 he was having child also, my lord.
Because you are not vigilant, that's why. So he was watching.
What
he briefed his counsel to count the dates.
So what he submitted, what I want to say, my lord, though he filed divorce petition, my lord, but he was living with his second wife, my lord, and
okay.
So
now
this is on my misery, my lord. I am taking care of my.
So you going to that part now. So be a issue of alimony which has to be.
That I understand, my lord. 2010 till date, my lord. I am taking care of my child, my lord.
Yes. Maintenance.
No maintenance, nothing, my lord. And he is earning, my lord, in dollars, my lord.
All right. So,
and baseless allegations, my lord, adultery with my father, such type of remarks, my lord. This person does not.
With his father.
He is making allegations, my lord, that I am having adultery with my father. Now he says, my lord, that I will go to USA and stay with one Prabhakaran. What this is all, my lord, there, my lord. That I want to go to USA and shift with Prabhakaran, my lord. And, my lord, time and again, my lord, I tried my best to settle with him, thinking of my child, my lord.
Whenever we try to pay maintenance, they rejected it, my lord. They have never accepted any money from
for
us.
1.5 crores you pay, we will give you a decree of divorce.
I have to seek instructions because one point he.
They can call your client and tell us in 5 minutes.
Please, I'll.
Or else your marriage becomes illegal.
I understand.
Yes.
Yes.
That's but
That would have
1.5.
its own consequences in your green cards.
He's not in USA, he's in Hyderabad only, na?
He's in Hyderabad. Green card is expired, my lords. I can file now. He's not going back, my lords.
Get it revived.
1.5 crores will be very, very difficult as per my lords. Some.
Find out.
I'll get.
You're all right, keep your wife and son with yourself.
We dismiss it, but finish.
I totally understand, my lords. I'm at your lordship, my lords, but 1.5 lakhs is going to be very difficult. I'll take instruction, my lords. Lordship.
Not lakhs.
Oh, sorry, my lord. 1.5 crores. I'm so sorry, my lords. Lordship, may tomorrow, my lords, or Friday, my lords? First.
Friday?
Friday, my lords.
All right.
I'm grateful.
Look, during the course of arguments, a figure of rupees 1.5 crore as one-time permanent alimony has come up, cropped up, full stop. Counsel for the petitioner husband wants time to obtain instructions. List again on Friday.
In the meanwhile, I'll file an affidavit regarding green card and the property also, my lords.
Come back ready with that. There's no need of any affidavit.
I understand. But my lords, but I have to indicate 1.5 is very, very difficult for him.
Sell off some of your property.
It's not his property. It's his actual property. There are siblings also. Not
Father's property.
Father's, mother's property.
Father will help you, sir.
Father's property, my lords.
It's yours.
Ancestor property.
Anyway, you
I'll take
come
instruction.
back if you're not interested in
I'm grateful.
further argument.
I'm grateful.
How do you get it?
Public notes.
I'm praying for a Passover, Lord. So Guru Krishna Kumar is leading me.
Passover, it may not come, then you might as well take a day. Who appears for the petitioner?
One Mr. Kapoor.
He's also not here.
I'm for the petitioner.
Then why are you shutting on the... Mr. Ravi Prakash, you
Seeking password there.
All right.
Pay attention.
password. You are for respondent.
Yes, Your Lordship, responding.
Next.
Your Lordship, item 28 was mentioned before lunch, Your Lordship. I'm being led by Deputy Advocate General. I'm seeking for 2 weeks accommodation, Your Lordship.
Why was it mentioned?
It was mentioned because, Your Lordship, we have drafted the reply and we are awaiting the executed reply on behalf of the government to be filed, Your Lordship. I'm appearing on behalf of state.
State of Chhattisgarh.
Yes, Your Lordship.
Reply. No, petitioner.
So there is a connected matter, Your Lordship. In the lead matter, we are respondent and we have filed a cross appeal, Your Lordship, because we are also impacted.
28.1.
Yes, Your Lordship.
That is by Bhupender Prasad. The state is a respondent.
Yes, Your Lordship.
In that, your portal is under preparation.
Yes, it is already done, Your Lordship. I'll just say, I'm just yet to receive it. I'll file it.
On
Your
the
Lordship.
request made on behalf of the Council for State of Chhattisgarh. List again after 1 week, 2 weeks.
2 weeks, Your Lordship. I'll
2
be
weeks.
grateful to you.
To enable the state to file its counter, to complete its pleadings.
Yes, Your Lordship. Deeply obliged, Your Lordship.
Next. Yes.
May it please your lordships.
Yes.
But here, the petitioner is a recognized private institution, Bullet, aided, not privately aided institution, recognized under the UP Madhyamik Parishad Act, Bullet, seeking provincialization since 2005, Bullet. Communications, your lordships, numerous communications with the government are post my representation showing that I fulfill the criteria of 7 kilometers in intermediate college, and Bullet, the inspections have been done. Finally, Bullet, in 2027 to 2020, the government comes out with a policy that now we no longer, after 17 years of our representation, Bullet, now that the government says that there's no policy which says that you can have provincialization. And the Honorable Division Bench says, Bullet, in that
Mr. Verma, how do you have a right?
No, certainly not a right. But what I'm saying is the government is no. But I wouldn't have. Would have been outside the court. I've been out of the court if that was the case. But certainly I have no right. At the outside, as an officer of the court, I will never say that.
Yes.
Your Lordship may just have my application. But the management I applied, and Your Lordship may just have page 31, appropriate page 37. Way back in 2006, they say that yes, I fulfill all the criteria of provincial. 400 students at stake in a remote area of Hasanpur. No, I am not able to run it because in 2008 the cost of salary of teachers was 25 lakhs, and today it's a I bow down. What is the? I have an uphill task.
This is a good lucrative business.
Not lucrative business, but not.
Please read the High Court's order.
Yes,
I two institutions on granting it within 7 to 10 kilometers.
I answer.
All right, Mr. Verma.
I'll answer. Just one respectful submission.
What?
That all that I'm saying is that the High Court says that two institutions. Why it happened? When my application was there was no institution. And finally,
challenge the recognition and being taken on grant by
another round, and we went to the High Court.
If you have a competitor who is getting benefit over and over, marching over you,
all the time.
There are two without granting it also.
Oh, yes.
If they can survive, you can also survive.
Each one. What I'm saying is very well.
Otherwise,
Thank you.
provisions of merger are there.
Very well. And all that I'm saying is students, 400 students are at stake. Very well.
Giving them education. Yes, next.
My lords, in item 32, I'm seeking a short accommodation. The arguing counsel is...
How short?
My lords, may fix any date for final arguments. All the pleadings are complete in the
When
matter.
do you want it?
My lords, before vacations. My
Then
lords,
you should be ready today.
my lords, the arguing counsel is not available.
It's not well. Item 32.
Item 32, my lords.
All right, on the request of counsel for petitioner. Case is adjourned. List again on 14th May.
14th May. Grateful lords.
May it please to below. My lord, item 33, in spite of the direction made by the court.
Yes.
No counter has been filed by the other side.
My lord, I am seeking a short accommodation, my lord.
Well, that is
My
too
lord, to
much.
filing a counter affidavit, my lord.
Well, last opportunity was given by
Lord,
my
there
lord
is
earlier
certain
also.
document need to be
Now
filed.
2 years has gone by, my lord. Last time also it was the last opportunity.
My lord, disciplinary
They are coming with
proceeding
SAP.
issued against the petitioners, my lord, which he got dismissed from the service, my lord.
I'll be answering everything therein.
Document need to
Are
be
you
filed,
willing to
my
file the counter? Otherwise, I can start also.
My lord, I am seeking a short accommodation.
counter affidavit?
2 weeks, my lord. I am seeking it's a last opportunity. It's a humble request.
On the request of counsel for the respondent, the matter is adjourned to 7th May 2025. On or before the said date, counter affidavit may be filed.
My
No further time would be granted for the said purpose.
I am honored.
Next.
thank you.
ये बीच में जंप कैसे कर रहे हैं आप? 34 भी हो गया। सुबह 8 डिलीट हुआ है। Item 36. Yes.
My lord, I seek time to serve someone in this matter. I seek time for service to someone.
Service is not complete.
R1 and R1 to 4.
In some.
1 to 4. Everything is incomplete.
Everything.
That is all. The other things R3. R3 they have served for deletion. Other respondents are not served.
Not served, not served, not served. 1, 3, 4, 5.
1, 2, 4, and 5.
1 and 2 not served, 3 not served, 4
3
not
delete.
served.
3 has been served, Lord. I am appearing on behalf of
It's not deletion. They moved an application for deletion.
Lord, I did not know this fact, but I have been instructed
That
to
has
appear
been
because
allowed also
we
and
have been-
cost title has been amended also.
Please, Lord, but we did not know this fact, Lord, because someone has been issued to respondent 3.
So, awaited a notice. So this after 2 weeks with fresh office report on service.
Obliged.
1 and 2 notice I have stopped and 1. Just
Just 1 minute, come back.
Yes, madam. Yes.
You have to provide complete address of respondent number
1 and 2.
1 and 2.
Yes, madam.
Okay. According to the office report, on account of insufficient address of respondent 1, 2, and 3, the service is reported to be incomplete.
No, so 3 I am appearing, Lord.
That's all right. 3 you are appearing. 3 already deleted.
Please.
1 and 2 ही कर दीजिए. Counsel for the petitioner is granted 2 weeks time to provide the complete and correct address of respondents 1 and 2. Upon such information being provided to the registry, such notices may be issued to them. Next.
We're seeking a passover, please, your lord. We're being led by Mr. Nat Karni, Maharaj, on Lex, Maharaj, seeking a passover, my lord. We're being led by Mr. Nat Karni.
Passover would.
Passover would be in next week, next Tuesday.
Very well, as you
Very
But
well.
can I only make one prayer, my lord? It may be high upon the board, my lord.
How does it make any difference?
No, very well. If it is taken up,
are ready to do it, it will be taken up. If they are not ready, it will again be adjourned. Whether high or low.
No, let it be on our understanding that he is seeking a Passover. We will do it on the next day.
Each and every day we are here, my lord. Unfortunately, today he's on his legs, my lord. We do our test lots of.
The request made on behalf of Mr. Nat Karni, General Counsel, Senior Counsel appearing for the respondent. Case is adjourned. List again on next Tuesday.
Nice.
May it please watch. Because on 25th of March, your lordships had directed us to give the details as to when the judgment was passed, signed, when was the decree signed. Now, we have filed the additional document. On the 23rd of December, the judgment was signed by the learned judge. A decree was signed, my lords, on 12th of January. It was prepared on 12th of January, my lords. Your lordships have the last order, my lords.
29th January.
Yes, my lords, on 25th of March, your lordships had passed the order. If your lordship sees the order.
In the meantime, parties may provide the details regarding the date on which the judgment of the trial court was
Yes.
signed by the presiding officer.
Yes, my lords.
And file sent to the section.
Lordship pleases.
The date on which the decree was prepared and signed.
Lordship pleases.
Yes.
Now, my lords, on basis, my lord, we have filed this additional document, giving all those documents.
Yes.
It is, my lords, titled as application seeking permission to file additional documents with affidavit. It was filed on 12th of February 2025.
Find out that application.
My lords.
When did you file it?
12th of February 2025. Huh?
We have no. How is that
Milord, I'm very sorry. Milord, I'm very sorry. Milord. It was filed on 19th of April.
19th April, yes.
This is Jaideep Patil.
We have also filed.
I have filed
Same day,
affidavit
19th
on the same lines on 19th
Yes.
of April.
19th April 2025.
I've also annexed the Roznama, my lord, in my affidavit.
Yes.
What was the issue?
My lord, what has happened here, I am the original defendant. The plaintiff filed suit for specific performance, your lordship, that was decreed. And a time of 1 month was given in terms of Order 20 Rule 12A to deposit the balance amount. The plaintiff was directed. He fails to deposit that amount. There is admittedly a delay, my lord. He files an appeal on the ground that that condition itself is illegal. That decree was entirely in his favor in accordance with the prayer he made in his plaint. It was granted to him. Specific performance in the alternative refund, completely granted him. He files an appeal that the condition of alternate relief of refund of amount is illegal. The first appellate court actually allows the appeal and directs that condition to be illegal and deletes it, when in fact it's a mandate of Order 20 Rule 12A. And the second appeal was also dismissed, my lord. Now the issue here is, your lordship, that he failed to deposit the amount within the requisite time.
So, because I have to show
His
you-
ground is, my lord, is lack of knowledge.
No.
No.
Not ready. Decree
If I
was
may-
not prepared.
Milord, if I may
Certified copy, my lord, he
Yes, if I may argue my point. Now, my lords, if your lordship sees the order which was passed, my lords, your lordships have the affidavit. My lords, application seeking permission to file additional document on behalf of the respondent, Mr. Anshuman Ashok.
99058.
My lords. Now, if your lordship sees,
Yes.
my lords, the order was passed, my lords, on, if your lordships have paragraph 4, I have given the entire sequence, my lords.
Yes.
My lords, that the suit, my lord Justice NATH has.
Yes.
Well, para 4 onwards. That the suits for specific performance with a special civil suit number 40 of 2011 was filed by the petitioner on 5th of February 2011 and was decided on 23rd of December 2016. Now, this judgment, which was passed by the Learned Civil Judge Senior Division, Amravati, was signed by him, my lords, on 23rd of December 2016 itself, I must say. Now, if your lordship sees the order of 23rd December 2016, the directions were passed. The conclusion is at page 37-38 of my additional document itself. So I have annexed it for your lordship's convenience.
Yes.
Now, this was admittedly signed by the learned judge on 23rd of December 2016. Milords, on 1st of February, milords, on 1st of Jan, in fact, I applied, milords, on 26th of December 2016.
For copying application.
Lordship pleases. Milords, despite the fact this judgment was signed on 23rd of December, which says decree be drawn up accordingly at the end clause 5, milords, the decree was drawn on 12th of January 2017, milords.
Yes.
Now, milords, if I see 12th of January 2017,
Yes.
I have admittedly deposited on 6th of February 2017. So from the date when the decree was drawn, I am within the time stipulated. What my learned friend is saying, that because the judgment was passed on 23rd December, and if you take it from 23rd December, you have crossed 1 month. Now, I ask myself a question: if in such a case wherein a judgment is passed, signed, but the decree on that basis has not been drawn, let's say for 1 month, and the time granted is only 1 month. So whether the person who has succeeded is, my lords, will be thrown out on the ground that, sorry, from that date you have already, the 1 month has crossed. Admittedly, from 12th of January 2017, 30 days had not passed it. In any case, my lords, that particular clause also, clause 5, wherein I was given that alternative relief, that was also challenged by me in the first appeal. My learned friend has said, in fact, he had said last time that there was an application filed by me for condonation of deed. My first argument is that condonation application was not at all needed. And even if it was there, it was dismissed for non-prosecution only for the reason that was decided in 19, wherein my appeal, the first appeal wherein the decree was modified, was done in December 2018 itself. So therefore that application, whether it was prosecuted, non-prosecuted, it was not at all needed. The learned lawyer who was appearing for me was probably under the bona fide mistake that yes, 23/12, so 23/12, 1 month is 23 or 22 January, and therefore there is a deal. But admittedly, that the decree was drawn on 12th of January 2017. I have mentioned that, which is at page 43. If your lordships have 43, that is the decree. The decree starts from page 39. (42), my lords, para 7 onwards. The suit is coming for final disposal before Shri S.S. Oza, Civil Judge, Senior Division, Amravati, in the presence of Shri S.R. Sarda.
19th April कोई फाइल किया
18th or 19th, ma'am.
It should.
There is no dispute that the learned civil judge had signed the judgment on 23rd of December. I am not at all disputing. In fact, I have the
decree was not
yes.
valid, so you did not deposit.
Yes, my lords. Now, until this decree is there,
Count that 1 month from the date the decree was drawn.
has to be, my lords, until the decree is drawn, my lords. Now, my lords, may kindly see page 42, the order, this decree, my lords, starts from page 39, and page 43, after the bill of cost, my lords, given under my hand seal of this court on 23rd December 16, and thereafter, my lords, may see S.S. Oza, Civil Judge, Senior Division, 12th January 2017 is his signature, my lords, on the right hand side.
Your draft was ready on 4th February.
Yes, my lords. My draft was ready on 4th February. I submitted on 6th February itself. Your lordships have page 43 minutes.
What is the date on which you received this certified copy?
On 1st of February, my lords, in fact, I have said so also. It was in February 2017, my lords, when I had received. My lords, the certified copy was received by me on 1st of February 17. On merits.
Your lordship.
You also admit that decree signed on 12th January by the.
Your lordship, the decree is dated 23rd December 2016.
Yes.
23rd December 20. My lord, the decree is dated, it is merely signed on 12th of January. It is a ministerial act of the court to sign on the decree.
Depend on the date, when the officer marks his date.
Your lordship.
Decree can be subsequent to the order.
Your lordship, may I bring your lordship's attention to order 20? May I read your lordship? Order 20, rule 3, your lordship. May I read, my lord?
Judgment to be signed. The judgment shall be dated and signed by the judge in open court and the time of pronouncing it, and when one signed shall not afterwards be altered or added to, save as provided by section 152 or on review. The minute the judgment is signed, my lord, there is finality attached to it and it cannot be altered or added or changed. The Roznama reflects that he was present in the court. Your lordship, may I bring your lordship's attention to the Roznama? He was present in the court.
His counsel was there.
And he was aware of the judgment. Order 20 Rule 3 makes it clear that there is finality to the judgment once it is signed and it cannot be altered. Now, your lordship, may I bring your lordship's attention to Rule 7? The decree shall bear the day on which the judgment was pronounced, and when the judge has satisfied himself that the decree has been drawn up in accordance with the judgment, he shall sign the decree. The decree shall bear the date on which it is pronounced. The date of the decree is the date of the judgment, not
mentioned here.
And hence it is not 1217 on which he merely signed the decree after verifying as a ministerial act that the decree is the same as that of the judgment. The date of the decree will continue to remain 23rd 12/2016 and therefore period of limitation will begin from then. Your lordship, order 20 Rule 6 may be seen. Contents of decree. Your lordship, I have one extra. If you...
We have. Order 20 Rule 6.
I showed order 20 Rule 3 first, my lord.
Yes.
Then order 20 Rule 7. And now I am reading order 20 Rule 6. Contents of decree. The decree shall agree with the judgment. It shall contain the number of the suit, the names and descriptions of the parties, their registered addresses, and particulars of the claim, and shall specify clearly the relief granted or other determination of the suit. The decree shall agree with the judgment. The decree cannot vary from the judgment.
Reading with 6.
Yes, my lord. So, three things, your lordship. First, the judgment is pronounced, it is signed. There is finality attached to it. Then a decree is drawn up which has to necessarily agree with the judgment. And thereafter, once the concerned presiding officer verifies that it is drawn up in accordance with the judgment, it is only a ministerial act on his part to sign on it. In that regard, your lordship, may I show you this honorable court's judgment, your lordship?
Yes.
Yeah. 1999 8 SCC 315. You can have it, sir.
Thank you.
He cannot hide behind the fact that the decree was signed on 12th January.
Yes.
Your lordship, you have the judgment?
Yes.
May I read para 7? It is this judgment, my lord, is in the context of execution of a decree.
Yes.
From a perusal of the article extracted above, it is clear that for execution of any decree or order of a civil court, a period of 12 years is prescribed. Column 3 contains two limbs indicating the time from which the period of limitation begins to run, that is the starting point of limitation. They are when the decree or order becomes enforceable and where the decree or any subsequent order directs any payment of money or the delivery of any property to be made at a certain date or at recurring periods. That is not relevant, my lord. The proviso says that there shall be no period of limitation for enforcement or execution of decree granting perpetual injunction. That is also not relevant. We are concerned here with the first of the above mentioned starting points, namely when the decree or order becomes enforceable. A decree or order is said to be enforceable when it is executable. For a decree to be executable, it must be in existence. A decree would be deemed to be in existence immediately on the pronouncement of the judgment. But it is a fact of which judicial notice may be taken of that drawing up and signing of the decree takes some time after the pronouncement of the judgment. The Code of Civil Procedure itself enjoins that the decree shall be drawn up expeditiously and in any case within 15 days from the date of judgment. If the decree were to bear the date when it is actually drawn up and signed, then that date will be incompatible with the date of the judgment. This incongruity is taken care of by Order 20 Rule 7, which inter alia provides that the decree shall bear the date and the day on which the judgment was pronounced. Now, your lordship, I did not read Orders 20 Rule 6A. I'll read here, my lord. What 6A says that the last page of the judgment, the last para of the judgment, shall bear specifically what the decree is, And so long as the decree has not been drawn up, the last para of the judgment will be treated as the decree, and the party can either file execution or appeal based on the last para. And that was available on 23rd 12/2016 in terms of Order 20 Rule 6A. May I read further, Your Lordship?
Yes.
Without quoting, my lord, should I quote 6A? Or do I move on?
No, read it.
Last para of judgment to indicate in precise terms the reliefs granted. Of the judgment. Apologies. So, Your Lordship, the decree was available to him on 23rd December. He was aware of it. It was his obligation to abide by it. He failed to do so. And a decree which is entirely in his favor, he takes the advantage of Section 96 and files an appeal which is entirely illegal because a party is filing appeal against a decree which is in his favor and circumvents the mandatory mandate of Order 20 Rule 12A. And Your Lordship, despite his lack of readiness, he is trying to take advantage of two things. That is my submission, Your Lord.
Yes.
And my lord, also his pleadings will also have to be seen why there's a 15-day delay. His pleading is that he applied for certified copy and all that. So the pleadings in that context have to be seen. Some other explanation cannot be supplied now. His explanation is certified copy and nothing else. So only that can be explained.
Regarding the drawing of the decree.
No, my lord. He says he applied for certified copy. It was received in February and all that. And then his lawyer was in some wedding in Nagpur and so on and so forth. Only he cannot supply any other pleading now at this stage.
Yes.
In fact, I had challenged the clause 5 of the decree with the order.
Mr. Prasad,
Yes.
you tell us one thing.
Yes, my lords.
Clause 5 would come into play only if clause 1 failed.
Yes, my lords.
The refund of the money would come into play only where you do not deposit and get the same date executed.
Yes, my lords. Sorry, my lord. My lords, I had, it's not that if you.
What is the decree? What is the judgment, final operative part of the judgment?
Yes, my lord. Judgment and decree dated so my lords, the decree is.
Yes.
Page 42, my lords. Both parties, plaintiff to deposit remaining sale consideration as per the earnest note within 1 month in the court.
Yes.
Part 1. Part 2, after deposit of remaining sale consideration,
Yes.
defendant shall execute sale deed of suit properties as per the terms and conditions recorded in the earnest note within a period of 1 month. Plus, I'll go to clause 4.
Read the next sentence.
Lordship. Otherwise, plaintiff having liberty to get execute the sale deed from the court of law.
Provided you had complied with 3.
Yes.
Correct?
Yes, my lords. Now, this is, they
Now
are
if-
together.
Now you come to 5.
Yes. If plaintiff failed to deposit
Correct.
remaining sale consideration within a period of 1 month, in that event, suit is decreed for alternate prayer of refund of earnest money with interest at the rate of 9% per annum from the date of execution of earnest note till realization of entire amount. Now, my lords, I was aggrieved by this particular my lords, direction and order, and I challenged.
That is clear.
Will you please let me argue?
Mr. Prasad.
Yes, my lord.
If you had complied with clause 3.
Yes, my
There
lord.
was no need of going to clause 5.
My lords, for the reason, since it is coming.
That shows that you are yourself in a dilemma. Whether to get clause 5
No. My lords, the appeal is separate, my lords. Appeal is
separate. Why are you required to file an appeal
Yes.
at all?
Because, my lords, as far as this alternate prayer which was granted to me, my lords, I said, sorry, I am not.
Coming to play only when first fails.
Yes. Now, I did so. It is not that I have not done it. My lords may kindly see on 4th of February, I have deposited the amount. On 6th of February. If I take it from the date of certified copy, my lords, when it was given to me, within 2 days I have deposited. It is not that there is a delay on my part. If the judgment has been passed on 23rd of December, I have applied 24th and 25th December were holidays. On 26th December, my lords, I have applied for the judgment, my lords, certified copy.
Yes.
It was provided to me, my lords, on 1st of February 2017. In any case, if we see Limitation Act, my lords, this limitation, even if we come before your lordships.
For filing of the appeal.
Yes, my lords.
Yes.
This is a question of limitation of depositing.
So therefore, my lords, may kindly see, if your lordships want to see my conduct, please see on 23rd January, the date decree has been, my lords, signed by the judge, learned judge. And thereafter, my lords, the High Court, the first appellate court has modified the decree. The decree has, my lords, been modified by the first appellate court. He has lost. I have partly succeeded before the first appellate court. He again thereafter went to the High Court, my lords. Page 20. My lord, the doctrine of merger, in that case, my lord, the doctrine of merger will apply, and the, my lords, the trial court does not become functus officio if 30 days is over. Show me specific in fact, section 28.
You also challenge the decree or not?
Yes.
Your lordship, since it was against me, I have challenged it.
Challenge it.
On merits.
You lost it.
I lost, my lord.
From the High Court.
No,
Yes, first appellate court and then High Court.
Then High Court second up. Yes. And in the first appellate court, this issue was framed. Page 162. issues point 7 and 8 on this aspect was framed. Kindly see page 162, the first appellate court. Whether any interference is called for in the impugned judgment and decree, whether plaintiff, that is me, has made out case for extension of time to comply with clause number 3 of operative order of impugned judgment and decree. These were framed. Both the parties had filed first appeal. My first appeal was RCA number 32 of 2017. It starts from page 154.
When did you file the appeal?
I had filed it on 27th of February 2017. My learned friend had filed it on 31st, no? 31st of January 2017. So both of us had filed. Now, as far as he is concerned, his first appeal, he lost. The two issues which were framed, wherein the first appellate court, considering these 2 points at page 162, has held in my favor. If your lordships have the point 7 and 8 at 162 and the finding by the first appellate court at 170. My lords have 170 bullets?
Yes.
Now, my lords, point 7 and 8 are whether any interference is called for in the impugned judgment and decree. Yes, only in operative part of order. And 8 is whether plaintiff has made out case for extension of time to comply with clause number 3 of operative order of impugned judgment and decree in the affirmative. Now, why is it so? Page 170, para 27 onwards.
Yes.
These points relate to the order passed by the learned trial court in clause 4 of the operative order. The said part is to be read with clause 3. Learned trial court has directed plaintiff to deposit remaining sale consideration as per earnest note within 1 month. The consequence of failure to comply with such order is mentioned in clause 5 of operative order. The consequence is that failure to do so, the suit is decreed for alternate prayer or refund of earnest money at the rate of 9% per annum from the date of execution of earnest note till realization of entire amount. Mr. Sarda has criticized clause 5 of the operative order. According to him, said part of order is contrary to the provisions of law, particularly section 28 of the Specific Relief Act. He has drawn my attention to the section 28, which reads as under: rescission in certain circumstances of contracts for the sale or lease of immovable property, the specific performance of which has been decreed. Where in any suit a decree for specific performance of a contract for the sale or lease of immovable property has been made, and the purchaser or lessee does not within the time allowed by the decree or such order
such further
period as the case may court may allow, pay the purchase money or other sum which the court has ordered him to pay, the vendor or lessor may apply in the same suit in which the decree is made to have the contract rescinded, and on such application the court may by order rescind the contract either so far as regard the party in default or altogether as the justice of the case may require. I'll read from this minute. Where a contract is rescinded under subsection 1, the court shall direct the purchaser or the lessee, if he has obtained possession of the property under the contract, to restore such possession to the vendor or lessor, and may direct payment to the vendor or lessor for all the rents and profits which have accrued in respect of the property from the date on which possession was so obtained by the purchaser or lessee, until restoration of possession to the vendor or lessor, and if the justice of the case so requires, the refund of any sum paid by the vendee or lessee as earnest money or deposit in connection with the contract. If the purchaser or lessee pays the purchase money or other sum which he is ordered to pay under the decree within a period referred to in subsection 1, the court may, on application made in the same suit, award the purchaser or lessee such further relief as he may be entitled to, including in appropriate cases all or any of the following reliefs, namely the execution of a proper conveyance or lease by the vendor or lessor, the delivery of possession or partition and separate possession of the property on the execution of such conveyance or lease. No separate suit in respect of any relief which may be claimed under this section shall lie at the instance of vendor, purchaser, lessor or lessee as the case may be, the cost of so and so, so and so. Thus, according to Mr. Sarda, the power to extend the period and to deposit money lies with the trial court. Secondly, consequence of failure to deposit amount as per the order of the court is provided in section 28 itself. The refund of sum paid by the vendee as earnest money or deposit in connection with the contract is envisaged in section 28 2B of the Specific Relief Act, the court ought not to have passed aforesaid orders which have virtually dismissed the suit for specific performance of the contract. Mr. Sarda would submit that in the present case, the decree is passed on 23rd of December 2016. Thereafter followed winter vacation. Judgment was pronounced on 23rd December, but judgment was not typed. This cannot be. It was typed and signed by the presiding officer. It should not have been there. Further, the council was informed that suit is decreed, but operative part of judgment and order was not made known to the council of plaintiff. I have showed your lordship that the decree was signed on 12th of January 2017. The council applied for certified copy. The civil court reopened on 2nd of January 2017. The certified copy was received by the clerk of the council on 1st of February 2017. At that time, it was noted that the balance amount of consideration is to be deposited in 1 month. The council on his part instructed plaintiff to immediately obtain demand.
Area of the land involved?
The total area, list of dates that.
My lord, at page 163, the calculation is there. Total is 0.89 R plus 0.78 R, 2.2 acres, my lord.
What is the total sale consideration?
My lord, the total sale consideration was 5,52,080 rupees, out of which 2,10,000 was paid at the time, my lord.
Advance.
At the time. And 5,52,000 is the total amount.
What was the amount to be paid at the time after the judgment?
350, the entire amount.
The remaining amount, my lord. Remaining sale consideration.
That's what I'm asking.
It was 3,50,000.
3,50,000.
Yes, my lord.
3.5.
Yes, my lord.
Total was 552.
Yes, my lord.
And earlier you had paid how much?
210.
210. Then 342 would remain. 3,42,000.
Yes, my lord. So it's not that I had paid only 5,000 and had an agreement executed and the majority of the money was to be paid later. I paid half of the money.
Less than half.
And what is the date of the agreement?
My lord, it is 18/8/2008. Agreement to sale.
And this is agricultural open land.
It's a agricultural land. I'm a farmer.
Yes. Now that money of 3,42,000 is lying with the court.
Yes, he has deposited it, but without any order of the court, my lord. In fact, his application was dismissed for want of prosecution.
That application.
For extension of time to deposit.
First appeal has been allowed in my favor. Look, there is nothing. Obviously, the application is separate. There is a document. I have annexed it. If my lord, may kindly come to.
Was there any interim order by the High Court, by the First Appeal Court against the either in his appeal or your appeal?
The decree has been modified now. The amount was paid. It is not that the amount was not deposited or has not been. The trial court had the money. So, and on page 53, the demand draft which was submitted by me.
Had the money, you could have continued with clause 4 and there was no need for you to file an appeal and press for clause 5.
No,
relevant.
May kindly see.
What were complied with.
May kindly see.
Nothing prevents him from depositing money. There's no bar.
May kindly appreciate the delay, even if there being a delay, let's see there is a delay, going with this fact, that if there is a delay, whether the trial court has become functus officio, whether the first appellate court had the power to condone the delay. The delay is not.
Once the delay is there, then you have to invoke section 28. Only then you can get an order of.
May kindly see your lordship. Your lordships have on this aspect, your lordships, (2025) 3 SEC 543. your lordships have, this was decided on 17 January. Your lordships have said that the courts do not become functus officio. And B, my lords, if the first appellate court, my lords, may kindly see the first appellate court, my lords, we were on point 7 and 8, my lords.
Yes.
Para 29,
Page?
my lords, 172 of the main paper book.
Yes.
My lords, para 29, further, my lords, para 29 at page 172.
Yes.
Further, the council was informed that suit is decreed, but operative part of judgment and order was not made known to the council. The council applied for certified copy. The civil court reopened on 2nd of January 17. The certified copy was received by the clerk of the council on 1st of February 2017. At that time, it was noticed that the balance amount of consideration is to be deposited in 1 month. The council on his part instructed plaintiff to immediately obtain demand draft favoring Court of Civil Judge Amaravati. Accordingly, on 4th of February 17, the plaintiff obtained demand draft of 3,50,000 and deposited in the court on 6th February 2017. Now, my lords, may kindly appreciate here, the moment my counsel informs me, my lords, I take 3 days, my lords. The plaintiff has also made application for extension of time to deposit balance amount for consideration in the court. The said application is registered as RMJC 198. The amount was actually deposited on 6th of February. Thus, there is a delay of only 15 days, which is justified by the plaintiff in the form of above factual aspect. Accordingly,
So how much penalty will you pay for this delay?
I will leave it to your lordship. I understand. Milords, in fact, my instructions are thrice. Mediation was called. He did not come. Even the matter was listed before the Lok Adalat, before your lordships. He did not participate. I was there, my lords. So I'm just showing that it is not that we never wanted to. But the fact of the matter is he neither attended the...
My lord, may I submit?
He did not attend. We attended, he did not attend.
May I submit, your lord?
Where is this ground which he has taken on this aspect? And yes, अपने मन से नहीं बोल.
So that he may leave your property.
I can do that, my lord. I have
This
my
conduct-
instructions on that. My lord, 1.5 times I can pay.
What?
Or maybe twice as much I can pay, my lord.
Because I will pay.
My lord, I'll pay interest on that.
This is what he is interested in.
My lord, he has paid me 2,10,000. I can pay him 4,20,000 along with interest from the date, my lord, 2008. From the day agreement to sale was signed in 2008 at 6% interest.
He will pay you 3 times.
Yes, I will pay 3 times. Lord.
Okay.
Yes.
But I'll pay that. I'll pay 3 times.
His conduct may be seen.
Your lordship, the decree for specific performance doesn't exist in the eyes of law anymore.
He's misusing
Your
his
lordship,
dead daughter.
my lord,
Saying that I had taken money for that girl's
Education.
No, not education, medical treatment.
yes, my daughter died, your lord.
That girl was in the she was in the railway hospital. Not a single penny was paid by him. This is very unfortunate. A person, such a person, 3 courts have held that it has been a wrong statement made by him.
My lord, it was a money lending agreement. Your lordship, I will not go into that.
No, you
This
have to-
decree for specific performance, my lord, is a matter of contract.
Yes.
And there was a specific time granted. The time elapsed, the decree doesn't exist anymore in the eyes of law, your lord. The decree doesn't exist anymore.
Now that amount is lying with the trial court, executive
Yes.
court
Yes.
since 2017.
Yes, my lord.
In some FDR or something?
Because we had deposited it in by way of a demand draft. It is for the learned district judge to see whether he would have put it in the
Whether it has
interest.
been credited to the district judge's account or not, that you don't know.
That has been accepted because they have given us a receipt that the DD has been accepted by the learned court, my lords. English, no?
54.
Hmm?
54. 54.
Acha.
53 is the demand.
Hmm.
In the name of civil
Hmm.
action.
Because it is in the name of the learned civil judge senior division Amravati, so normally
If that accounts the name of the court, it must have been the worst.
it, Lordship pleases me.
My lord, but
55 lakhs.
What's Milot, give me 5 minutes.
5 minutes.
Yeah, give me 5 minutes. Lordship.
Item number?
39.
39, Your Honor.
What is this?
my lord, in this I had filed
Yeah,
a
the petitioner, I'll just give the gist of the matter, Your Honor. Your Honor, this is a matter where I am in a very precarious situation owing to the ridicule of the society by a court's order. What has happened is my second marriage with the respondent has been declared as null and void on the basis that my first marriage was already in subsistence at the time of the marriage. Now, I'll just give the brief background, Your Honor. I was married to my first husband under the Nirankari customs. And immediately after that, I had taken a divorce under the same custom, Nirankari custom. Then thereafter, after a span of 5 years, I was remarried to the respondent. And then I was ousted from the matrimonial house. After that, the respondent filed a section 9, that is a restitution of conjugal rights petition, wherein he has duly disclosed this fact that I am divorced. That means he knew at that time that I was divorced. In that petition itself, it's mentioned. After that, that petition was withdrawn. Then he filed a section 11 petition seeking for divorce on the ground that I have defrauded. I have not mentioned about
That to be declared a nullity.
yes, my lord, that was allowed by the family court, upheld by the high court.
upheld by the.
Because they have alleged there was a custom, but it was their duty to prove a custom.
All right.
Yes, Your Honor.
Yes.
Now, Your Honor, my fact, the fact of the matter is that it is an admitted position that the marriage also happened under the same custom and the divorce also happened under the same custom. The trial court and as well as the high court has held that the marriage is.
Is it their case that they did not know about your first marriage?
That is the allegation
That
that
is
they are putting, but
you have concealed that fact of first
yes,
marriage.
yes, Your Honor. But they are very well aware of it, and the same can also be seen from the restitution of
Are
conjugal
you
rights.
resident of the same village or same town? Same
No, different.
No, different places. We had met at a common Nirankari
The
occasion.
second one is a love marriage.
No, that is also arranged.
Arranged marriage, we had met through common families. Point that is there that needs weightage is that if marriage also happened under the same custom and divorce also happened under the same custom, the trial court and the high court has specifically held that the divorce is not recognized because it did not happen according to Hindu law. Then how come the marriage is being considered? The same threshold has to be kept because
There was no valid marriage, therefore there is no valid
exactly
requirement of any divorce.
the same threshold has to be held for both marriage and divorce. If the divorce is being adjudged as being not existent because it did not comply with the Hindu rituals, the same thing is with the marriage. It is an admitted position that no satpati or no rituals were taken place. Then how can the marriage be? And the second very important fact is when the section 9, that is restitution of conjugal rights petition, was filed, admittedly the respondent has mentioned that he knew about my divorce at that point of time. If I had defrauded him,
section 9, why did you not join him?
Your Honor, he withdrew that petition, and I was out. I was tortured in my matrimonial.
Filed it, there was an intention to lift
After that, he withdrew it. I was being tortured in my matrimonial house. I was not being. My in-laws and my husband were torturing
So
me.
after I withdrew, then I tortured her.
No.
After I withdrew.
No, Your Honor, that was that is before that. In fact, I had.
Now today, what do you want?
Your Honor, this is a very precarious situation today because there is, of course, an irretrievable breakdown of the marriage. There is no, to the best of my knowledge.
Lord, irretrievable could be there when there is a marriage existing. Here, the marriage has been called as nullity by the board court below. They allege there is a custom in Nirankari sect by that method, and giving agreement, they can give a divorce. For proving a custom.
Marriage take place, the first marriage.
Lord, that is for them to prove.
Marriage also under the same custom.
Lord, may see page 6 and 7 of the paper book. High Court has crystallized all the evidence, and his father admits that they belong to Sikh community. If they belong to Sikh community, then it comes under the Hindu Marriage Act only. And what they say that we belong to a Nirankari sect, and in that there is a custom by which we can get a divorce by agreement. Assuming they are right, so then they have to prove that custom. On the contrary, I have summoned the people from Delhi Nirankari sect to my court, my lord, and they have given the evidence that we don't have such any this kind of custom with us. May keep page 6 and 7 of the paper book. It is a High Court judgment. High Court has crystallized each and everything there, my lord.
Just before that.
Just ma'am, 1 minute. Just 1 minute.
Page 5.
Page 7 of the paper book. Just page 7. Everything would be clear from that. Her father evidence, my evidence, everything is there, my lord. It has been quoted there. Page 7, if my lord may kindly see that. My lord is on page 7.
Yes.
That is what I'm telling. They have to bring the witness to demonstrate the custom was there. In government documents, they have mentioned every wrong thing, my lord. I'm not going out to all that aspects. I'm just coming to High Court. High Court has crystallized everything there, my lord. If my lord may permit, I can just read that, my lord. On page 7, my lord. Page 7, 8, my lord. Everything has been crystallized there, my lord. Here, petition examined. I have brought the evidence. Section 29, clause 2, my lord, is there. That relates to customs, my lord. She has failed to demonstrate that, my lord. Otherwise, by way of decree, only divorce can be given. I agree if custom is there, section 29, clause 2 is there. She has to fulfill it, not I have to. On the contrary, I have fulfilled it, my lord.
Don't discharge that burden of 29.
Your Honor, the burden is on me, but the burden, that is my humble submission, that the burden is with respect to marriage as well as divorce.
All right, dismiss next.
Your Honor,
Your
Honor, can I just make my submission with respect to this?
What more is the
Your Honor, if the marriage is only not proven, then where is the case of the divorce?
All right, next case.
May it please your lordships, I'm requesting 3 weeks time to file rejoinder. Counter has been filed by them in the month of February.
Concurrent findings of fact.
When you file a counter,
I filed.
when did you file?
February
we filed.
3 weeks time granted to the petitioner to file rejoinder affidavit. This thereafter. Next.
Grateful.
Please, your lordship. Please. Your lordship, in this case.
Yes.
I approached this honorable court against the order of the High Court, your lordship. And your lordship, trial court has given me an opportunity to meet the child, but subject to move an application on each and every time. Whereas the petitioner is living abroad, your lordship, and practically it is not possible that he should come and then he should move an application, then it may be heard and then it may be
By
decided.
the time it is time for him to go back.
And by the time will come and he will go back, your lordship. And it happened many times. And now since the order was passed by the trial court, since then it was very difficult. And now, your lordship, he has missed since last 6 months, more than 6 months, even to meet the child. Earlier he has been meeting the child. I have given the details of all those days when he has met.
What happened? Mediation also failed.
Mediation failed, your lordship. There was not much agreement, but your lordship, on certain points, the respondent is ready that his child should be able to meet the father. On certain occasion it is there, But your lordship, the whole difficulty is this, that this order is coming on the way. Because in case dates is fixed, that normally in other cases also it happens that there are fixed date during vacation, 50% days are with mother, 50% with the father. And then accordingly, they mutually decide first half will be with father, second half with the mother, like this. Even in case this arrangement is made, then your lordship, the father can come. He is willing to come here in India from 1st May to 30th May. And he wants to meet the child for during this period. A child is having vacation till 2nd of June, your lordship. So your lordship, right now, your lordship, I want at least this relief should be given. Trial is going on before the family court, your lordship, but the earlier court has not considered.
I am appearing for respondent in this case, my lords. With my lord's permission, may I kindly submit, my lords?
How do you justify this order of the High Court?
My lords, what has happened in this case is, my lords, my humble submission is firstly, my lords, the trial has commenced and it is going on, my lords. And my lords, it is proceeding, my lords. And secondly, my lords, my humble submission is that, my lords, it is never clear and it has never been clear as to when the, my lords, father is going to visit India, my lords. That is why this order was passed, my lords, by the learned family court as well as the Honorable High Court, my lords. My lords, because, my lords, he is working outside India, it is never clear as to when he will be visiting
But the
India.
High Court
my lords.
never dealt with the problem raised by the petitioner there.
My lords, but my lords, because
On every occasion, that issue has not been addressed. No, either it should have been rejected or accepted.
What is the
my lords, but
fate of the matter before the High Court?
my lords,
What
since the
matter was
trial,
decided?
my lords, since
There is
the
confusion.
trial is pending, my lords, that is why the, my lords, Honorable High Court has, my lords, my
I'm
lords,
sorry to interrupt your lordship. 10 dates have been given thereafter. When there has been nothing because we have filed a specially petition here. So we couldn't got even a single opportunity to meet the child. Whatever we were
my lords,
meeting, that has
what
also
has,
gone.
my
At
lords,
page
rather, what
18, I
has
have
happened
mentioned.
even, my lords, rather, what has happened even during mediation proceedings, my lords. My lords, the mother, my lords, she has agreed, my lords, the mother, she has agreed to most of the points, my lord. She has agreed, but my lord, just on 2 points, my lord, the father, my
Your
lord,
lordship,
he
right
didn't
now,
agree, my lord.
he is in UAE.
My lord,
UAE. He's
my lords,
working
now
there.
what
Your
happened?
lordship, he has taken leave now. He came for 15 days leave, but again he has taken leave from 1st May to 30th May only to meet the child. If your lordship direct, then your lordship, he will come on 1st May, provided child is given for half of this vacation. 1st May
My
to
lords, my
30th May.
humble, my lords, my humble submission is that, my lords, not only the, my lords, educational curriculum of the child is
It's a
different
vacation,
every
your
time,
lordship,
my lords,
till
but
2nd
even,
of
but
June.
even,
How
my
old is
lords,
the child?
she is
It's
7 years,
7
my
years
lords,
old.
7 years. Lord, she is also she is also enrolled
And
in many,
earlier also,
my lords,
at page 18,
my
I
lords,
have
if I
given
may
the
kindly
dates
submit,
when
my lords.
child has been staying with the father. Page 18 of the my specially petition, I have given various dates in para F. There are different occasions, different time child has been living with the father. And your lordship, there has been report of counselor also. Child was very comfortable with the
Lords,
father.
every time he has
It
moved
has been
application,
mentioned
my lords.
even in the order also, your lordship.
My lords, what happened? My lords, my humble submission is that, my lords, the child is enrolled in
An interim measure, we will provide that whenever there are vacations, they can be shared 50-50.
Please, your
And over weekends, if you are visiting, then weekends.
Your lordship,
Not every month, 15 days here and 15 days there. No.
Not your lordship. I'm only requesting from 1st May till 30th May he may be allowed, and another 1 month is for the child with to remain with mother.
Week or 15 days only. You can't have the child for the entire month.
She must be having her assignments and all those things.
Yes.
Please, my lord.
He will
Lords,
get it completed. Even in any case, your lordship, whatever is the, still there are another 1
If
month.
the school is open and there are no vacations, then you get only weekends.
Your Lordship,
Lords,
school
if
is
I may
open,
kindly
having
submit,
2
my
months
lords,
holidays. So he's asking
Lords,
only for 1 month, Your Lordship.
Lords,
2 month
the
holidays are
child is
there,
enrolled, the
and
child is
1 month may
enrolled
be
in
given to
many
him.
co-curricular activities, my lords,
Whole
as well.
June there is a
And
vacation, Your Lordship.
The co-curricular
Lords,
activities can continue. He's not taking the child out of town. The child will
my
sit
lords,
there. You can
my
always
lords,
guide
He will be here
and
only.
inform
my
that
lords,
as to where the child is to be taken for
my
co-curricular
lords,
activities.
You can have
my lords,
video
my
call.
humble,
Learning some sports
lords,
or for some dance, drama,
my lords,
whatever the child wants to
Lords,
do.
my humble submission is that, my lords, even on earlier occasions, my lords, the daughter, she has faced difficulty as, my lords, there were certain activities in church as well, which she was, my lords, supposed to attend. But, my lords, because of one difficulty or the another, when the child was with the father, my lords, the child could not attend those activities. My lords, and secondly, my lords, my humble submission
No,
is
no, we
that
will
as per
direct
my,
that the father will take care
Please,
lords,
that
as,
as and
lords,
when any
and
activity is required to be undertaken by the child, he will take the child there.
Yeah.
please,
Along with you,
lords,
you
and
can
my lords,
accompany.
Please, Your
Yes.
Lordship.
lords, if I may
Child
submit,
will be
my
there
lords,
in the same city only.
please,
Yes,
my lords,
please, Your Lordship.
and my lords, as per my instructions, my lords, he is not even paying the maintenance amount towards the child, my lords. So, my lords, my humble submission
That's a
is
different
when,
issue. Here we are
my
dealing with
lords,
the
my
visitation
lords,
rights
but
only.
my lords, my please, certainly, my lords, my only humble
Paying
submission is when he is
20,000.
not even
All
paying the
right, लिखिए
maintenance
ऑफिस
amount,
रिजर्व
lords,
counsel for the parties. If I हमारे पास देते हैं.
please, please.
Your Lordship, my only request is from 1st May to
We have understood your
Please,
request.
Your Lordship. Oblige, Your Lordship.
Yes, Mr. Prasad.
My instructions are, if your lordships can keep it, 20 with 8 weeks time, that's my instructions.
So is the counsel for other side?
He was here, my lord, he was here.
What are you haggling for 2025?
What has been my instructions? my lord?
Instruction is all right. Pay 25 lakh.
If can you, if 20, because we have already paid the entire.
Where is the counsel for the petitioner?
He was here. He is also seeking instruction whether he.
How much you want?
Contact with the client, I'm not able to, your lordship. My apologies for
Anyway,
that.
we are inclined to dismiss your petition, but still we are thinking something good for you. So they have agreed for 20.
But that is too low an amount, your lordship. Lordship, 20 lakh, your lordship is nothing, your lord.
He was paying me right now.
This is agree with you.
You pay them a crore of rupees.
Lordship may say
What is
that,
the value of the property?
but that I'll have to ask.
Let's-
client.
let's-
Your lordship may see that this degree of specific power doesn't exist in the.
All right, that's your submission. We have understood it. How many times will you repeat that? The degree does not exist. The degree does not exist.
There is a simple dismissal.
Your lordship,
Degree does not
The
exist.
consequence.
no, at least 30 lakhs may be granted, your lordship.
All right.
Plus,
30 lakh.
he was
25 lakhs. All right. Look, heard counsel for the parties. Considering the facts and circumstances of the case, and in order to do complete justice between the parties, we are not inclined to interfere with the improved order. However, we deem it appropriate that the respondent pays an amount of rupees 25 lakhs to the petitioner within a period of 8 weeks. Full stop. Further, the amount lying in deposit with the trial court will also be withdrawn by the petitioner along with any accrued interest thereon. The trial court shall release the said amount.
Please not really have not said.
Release the said amount in favor of the petitioner upon appropriate application being filed and bank details being provided.
Obligement.
deeply obliged.
Lordship's permission.
It is 4 o'clock already.
Yes, your Lordship's one urgent.
And no seniors to mention.
So, your Lordships, this is urgent. This is a demolition mentioning, which always is an exception, your Lordships. This is that matter, your
That
Lordships.
matter, yes.
So,
We
review.
recollect your friend had come at 1
Yes,
PM.
so review has been dismissed in the morning. Bulldozers are standing.
They were standing since the morning. They have done nothing.
So, your Lordships, I'm just asking
Bulldozers
for.
don't take all that time to.
It's
Actually, there is nothing happening.
Your Lordships, bulldozers
my
are
lord, they have
standing,
been wrongly
everything is
representing
happening.
there,
I'm
and
just
there's now an
requesting
order
your
of your
lordships
lordship.
to put it up tomorrow and no action
But-
till then. That's all.
My lord,
I
contemptuous
filed an
action is
MA.
being taken. They are actually representing over there that your lordships have given them a protection. This is completely
No,
wrong.
no.
They are
I'm
actually
sorry.
there
We have
stating
said-
that your lordships have actually allowed the mentioning and given them a protection. This is completely wrong conduct, my lord.
All
It
right,
is SLP
Mr.
that they
Sen.
withdrew.
Mr. Sen,
Yes, my lord.
if the bulldozers have not done anything so far since the morning, tell them to keep waiting till tomorrow morning.
My lord, they have. And in fact, 4 out of 12 applicants have agreed. They've consented with us that this application is
All
infructuous.
those who have consented, you remove their construction and get their
Your
papers signed.
lordships, whatever they've done till now,
My lord, this is a withdrawn SLP. I'm
Yes.
only bringing to your lordship's attention. They're asking for an order in a withdrawn SLP.
No,
in
they
a-
wanted
in a
to come back, they have that liberty to come back.
Yes, my lord. So, in fact, in the application, they say they'll file a SLP against a review, which they can, which your lordships have given them liberty to. But an MA in a withdrawn SLP, my lord, I'm only bringing that to your lordship's attention.
your lordships, that's what I could file right
No,
now.
how could you file an MA now?
Your
You should
lordships,
come with a fresh
that's
SLP,
also,
granted
that's
liberty.
also,
Grateful.
that's also ready, but that could not be numbered. That is my problem. So,
Number from there.
your lordships may,
Submission before the chief.
I will do that, but let them not continue it till tomorrow.
Get all this order from there.
I will do that, but your lordships, as of now, on my MA, because I've got a diary number also, your lordships have given me that liberty. It's a disposed of petition and I've filed an MA
You want a dismissal today or tomorrow?
tomorrow. Tomorrow.
All right, we'll dismiss it tomorrow.
Very well, well.
Lordships may tell them,
MA is dismissed, SLP will also be dismissed along with it.
obviously,
Yes.
your lordships may tell them to hold their hands till it's listed before your lordships. That's all.
My lord, I have
Lordships,
no
they
instruction
have
to do that.
pulled
They're
out,
on
I
their
have
way.
some,
In fact, the High Court has deprecated the
because
conduct
I will
today
never be put
because
back
they have
in
got the
restitution, your
SCFT Commission
lordships.
also to call.
High Court has must have already closed by now for today. So
Well,
tomorrow
in-
morning we will take up at 10:30.
In
Right.
fact, your lordship, they sought protection today. High Court refused it. Now,
Very
today,
Yes,
they
that
can't
is
be
what I've,
mentioning at
that's
4
why I've
o'clock,
come
my lord.
before your
You
lordships.
can't mention
Tomorrow,
at 4
don't worry.
o'clock.
With permission, may I mention
Great.
serial number 43?
Lordships may order this MA to be listed tomorrow. Diary number 21436 of 25.
We can't direct that.
Your lordships, it's in your SLP. I'm on,
Post of SLP, MA.
your
How
lordships
can
are,
you take it?
lordships are saying lordship will dismiss it tomorrow. Lordships may just have it
It is
listed.
dismissed today.
No, your lordships. Then
They taken on board on the mentioning of Ms. Vimadatta Makhija and its senior
your
counsel.
lordships, no orders
We
needed.
have
I
heard
will,
her at great length and also Mr. Sen appearing for the respondent corporation.
Respondent number 8, Malad. No, Malad, for the developer. Respondent number 8.
Respondent
I
number
was
8.
left with Mr. Diwan in the matter.
Find no
Yes.
merit in this application. It is accordingly dismissed. Let us put a closure now.
your lordships, but
Grateful.
my
Very
liberty with regard to SLP is open.
You come with your SLP, yes, that will be there.
Very well.
We will deal with it.
I'm very grateful.
Very well.
MA on board लेकर के dismiss कर दीजिए.
With permission, may I?
Lordships may say disposed of.
Dismissed.
Disposed of, your
Dismissed.
lordships.
Well, it's permission to mention at item 40.
No, no.
It's a contempt petition. Well, it's a patient is.
Inform the court martial, we will have it next week.
Well, it's
With permission.
No, next Tuesday, my lord, I'm requesting, the next Tuesday could be taken. This is the matter we have a lady for bedridden for 25 years, the direction to pay the compensation to the state government, which has not come. So my lord,
You are for whom?
I am for my lord, the appeal petitioner here. Their direction
And you are
was,
for?
well, same, we are on the same.
Both of you are arguing. No.
With permission, may I mention?
matter your lordship make it next Tuesday.
Next Tuesday.